from trade list for transfer item was 2nd April 64 of 1995.
One is for substitution.
आइए नंबर बताइए. Whose substitution?
For substitution of appellant number 40 note we have paid for deletion.
आप एक पिटीशन में मल्टीपल लोगों का क्यों ऐड करते हैं?
नहीं, एक appellant का है नोट एक रिस्पोंडेंट का. appellant का एक ही.
ऐसा नहीं करना चाहिए ना. इतना कंफ्यूजन होता है ऑर्डर लिखने में, करेक्शन करने में, इन लोगों को बहुत परेशानी होती है. यू शुड फाइंड सेपरेट पिटीशंस. एक पिटीशन में सब खिचड़ी बना दीजिए.
नहीं आप लोग से बोलो.
और उसके बाद आप लोग का एरर भी तो होता है ना, वो भी हम लोग को रेक्टिफाई करना पड़ता है.
इसमें भी एरर
बस
पार्टी पोजीशन टैली नहीं कर रहा कोर्ट के रिकॉर्ड्स.
कोर्ट के रिकॉर्ड से नहीं नोट जो ऑनलाइन स्टेटस है उसी को नोट टैली कर रहे हैं. ऑनलाइन स्टेटस भी हम लगाए.
ऑनलाइन स्टेटस इज नॉट डिसाइसिव. व्हाट इज डिसाइसिव इज द पार्टी पोजीशन इन द कॉस्ट आइटम.
एग्जैक्ट.
यस. कौन मर गया?
Yes, note. Here note, your lordship may kindly take note. My IA first. 13662. That is for substitution.
Yes. Who
Yes.
has expired?
Note respondent appellant number 40. Note Tetri Devi.
Okay.
And note his legal heirs are appellant number 41 and 42. But only one correction. Note 40 जो है status में जो दिखा रहा है क्योंकि उसी से हम नाम टैली करते हैं और हम लोग भी क्लाइंट को इन्फॉर्म उसी से करते हैं.
आप लोग के पास अपना मेमो ऑफ अपील नहीं रहता है?
अपडेटेड नहीं.
व्हाट डू यू मीन अपडेटेड नहीं है?
बट वो जो सब्स्टिट्यूशन कैरी
सब्स्टिट्यूशन कैरी आउट होता है, एबीसी कैरी होता है,
वो एबीसी कैरी होता है.
उसके बाद रीनंबर हो जाता है क्या?
बट अब पुराना केस नोट काफी सिविल लॉजिक
बात नहीं है. मतलब आई जस्ट डू नॉट नो. अब क्या करेक्शन हम इसमें करें? आपको
इनका नहीं हम इसे नाम दिए. नोट इनका जो है कोर्ट के स्टेटस में व्हाट आई हैव चेक नोट इज 27A एंड
वी विल नॉट डू दैट. कोर्ट का स्टेटस इज दैट इज ऑफ नो यूज. बताइए रिकॉर्ड नहीं आता है क्या यहाँ पे? कोई पहली बार तो डेट नहीं फिक्स हुआ है इसमें. इज इट कमिंग आफ्टर लॉन्ग टाइम? 25 साल बाद
ये एक बार आया था लिस्ट में जब हम लोग इन्फॉर्म किए क्लाइंट को और उसके बाद हम लोग वो स्टेटस भी उनको व्हाट्सएप कर दी कि उसका पुराना मैटर है.
स्टेटस उनको व्हाट्सएप कर दीजिए कि केस डिसमिस हो गया. व्हाट इज दिस? स्टेटस विल डिसाइड.
जो लॉजिक में ग्राम
यू जस्ट टेल अस कि कौन मरा है.
हां वो तो बताइए. नाम करेक्ट है खाली वो नंबरिंग अलग.
हम नहीं जानते. आप अपना रेस्पोंडेंट का नंबरिंग बताइए.
यस.
तो जिसको बोलिएगा उसको डिलीट कर देंगे.
नहीं तो नाम के साथ नोट आ जाए.
नाम के साथ क्या लिखेंगे आपको नहीं पता है? रेस्पोंडेंट नंबर मेमो ऑफ अपील खोलिए.
नोट
यू ओपन द मेमो ऑफ अपील.
यस.
या वो लेके नहीं आए हैं?
नहीं आई तो नहीं. Let me see first paragraph. Look, for deletion of we have stated.
I am at the cause title. You open the cause title and tell me which respondent has expired.
Not your lordship may first see appellant. Okay, your lordship is seeking for substitution.
Yes, I am seeing
Yes.
the appellant.
But this is 27A. Take 3 things.
Has expired.
Yes.
27B and 27C are on.
27C are on record.
On कौन मरा? Who else has expired?
But so far as other appellant number 6,
Yes.
but appellant number 2, Lord Safijan have died. And is legally as mentioned in paragraph 2, Lord.
Okay. Who else?
But then appellant number 5B, Aliman Ansari.
Kamrul Ansari है 5 people. 5A is
5B is
Atiullah.
Suleiman Ansari. Lord.
5A is Atiullah. 5B is Kamrul Ansari. 5C is Laliman Bibi.
Subscribe copy आपने लिखा है? 5B Suleiman But appellant number 5. 5.
Appellant number 5 में
5A.
तो already substitution हो चुका है.
हाँ,
5A
5
is Atiullah Ansari.
यहाँ पे भी लिखा है 5A सुलेमान अंसारी.
तो आप उसी से गाइडेड हो.
ये कोर्ट का रिकॉर्ड से लिखा है.
कौन
ये
सा
तो स्कैन
कोर्ट?
करके आया है. कंप्यूटर में जो लिखा है. और सर्टिफाइड कॉपी निकाले नोटिस पे.
रिकॉर्ड ना देखें. दिखाइए हमको. You don't see the record. I just do not. Show it to me. बताइए किसका डेथ हुआ. दिखाइए हमको दिखाइए. कॉज टाइटल से बताइए किसका डेथ हुआ. किसी अननेसेसरी किसी का रेस्पोंडेंट का डिलीट हो जाएगा ना. Then you will be in a big soup.
Yes, yes, no, it is a suit for partition. देखो I have to.
So 5B और ये क्या है.
But अभी हम लोग appellant में ये he is 5B नोट अलीमान. appellant number 5.
रेस्पोंडेंट नंबर सजीदुद्दीन मियां या बोले थे ना.
नहीं respondent नोट appellant बोल. appellant number 5B.
5B
Yes.
अलीमान अंसारी.
Yes. Aliman Ansari. He is legal as in para 3.
पैरा 3
And your appellant number 16.
16. साहिज मियां.
Yes, no, Sahib Jami.
साहिजन.
हाँ.
SAHEJAN. SAHEJAN.
Yes, no. SAHEJAN.
Okay. 16 has expired.
Yes.
So 140 appellant number 40 has expired.
Yes, no.
27A has expired. Then 5B has expired and 16 has expired.
Yes.
That's all.
Yes.
और तो कोई नहीं. 2 and 3 में इनका सब्स्टिट्यूशन है ऑलरेडी. बाकी लोग के ऑलरेडी रिकॉर्ड पर है. 27A का डेट.
But 27A जो है वही 40. वो स्टेटस में 40 है. इसमें पार्टी क्वेश्चन में 27. 27A ही मेंशन किया है.
Any objection?
Yes. Dr. B can para 7 of petition laws. आइए petition file appellants laws.
Para 7.
Para 7. I am permitted to read laws. The appellants were not aware about the substitution laws. Now, Dr. may kindly see order dated 25/8/2022. The appellants were very much aware regarding the filing of substitution petition, Lordship. This is absolutely wrong statement of the appellant's Lordship. Therefore, there is no sufficient cause, Lordship, has been mentioned.
Not aware about the substitution.
Lordship, the appellants where aware about the filing of substitution, may kindly see order dated 25/8/2022 Lord. Dear Lord, the appellants Lord to file substitution petition, meaning thereby the appellants were very much aware regarding the filing of substitution petition.
No, I don't get it. The substitution was already allowed.
No, earlier substitution mean my solicitor the appellants
Whose
were.
substitution?
But he is trying to say not that it is stated that appellants were not aware कि substitution का जरूरत होता है, and he says that earlier in 2022 they have filed a substitution with
Substitution
respect to
meaning
another
the appellants were very
respondent.
much aware
Therefore-
regarding the filing of substitution petition. This is my position. Therefore, Lord, sufficient cause has not been mentioned, Lord.
Partition suit है ना?
Partition suit. पच्चीस आठ 2022 में सब्स्टिट्यूशन फाइल किया है।
इसका आईए निकालिए तो आईए नंबर 4267 काम मिलेगा, डिस्पोजल हो गया। स्टेटस से निकाल के कभी रिस्पोंडेंट नंबर मत लीजिए। रिकॉर्ड देखिए, इंस्पेक्शन फाइल करेंगे यही मिल जाएगा, आपके घर तो फाइल नहीं पहुंचा सकते। ठीक है, प्लीज डोंट डू दिस, इट क्रिएट्स अ लॉट ऑफ कंफ्यूजन। स्टेटस में रिपोर्ट, व्हाट इज द स्टेटस का रिपोर्ट? स्टेटस इज नॉट एक्चुअली कोर्ट रिकॉर्ड। Status is for the convenience of everybody. Court record is what is there in the record.
आइए
4267 इसी में होगा। आइए तो हटा देते हैं ना, हो जाने के बाद 22।
Good answer.
आपको कुछ बोलना है? What do you mean that you were not aware?
But should not read what he has stated only in isolation, but we just place para 7. That the appellants were not aware about the substitution and the appellants were under the impression that as and when the case would be listed, they will be informed, and only when the case was listed under the heading targeted case, letter was sent as a second appeal was being quite old and contact number given in the file was no longer active, and therefore after receiving the said letter, the client came to meet his counsel on 7 September 2025 and necessary steps have been taken to filing substitution. That under the process, so your lordship has to see not the entire paragraph, that was paragraph 6 onwards.
Essay number 64
Yes.
of 1995 with ID number 13662 of 25. This petition has been filed. The learned counsel for the appellant has submitted that the petition has been filed for substitution of appellant number 40 27A 5A and 16 who have expired.
Not 14 but 27A. With technically 14. The lordship may also allow me to correct in the application.
Appellant number 27A 5B and 16.
Put 2 also. Sufficient. Appellant number 27A needs to be deleted. 2, 5B and 16 needs to be substituted.
फिर से लिखिए appellant number 27A 2, 5B and 16 whose names are
27A is your Tetri Devi.
ये सीक्वेंस भी आपका उल्टा
But पहले खाली डिलीशन वाला कर दीजिए उसके बाद substitution.
who are Tetri Devi, comma 2 comma
For 2 Safijan Mia.
Safizan Mia,
Yes. Then verse 5B is Aliman Ansari. Appellant 5B.
इस पे नाम नहीं लिखे हैं. Appellant number 6 लिखे.
6 you can note. One tally value note. इसका substitution son.
5B is Aliman Ansari
Yes. And 16 is Sahejan Mia.
and 16 is Sahijan Mia. The learned counsel prays for and is allowed to correct the appellant numbers in the interlocutory application during the course of the day in reading. We have submitted that so far as appellant number 27A is concerned, namely Tetri Devi, she has expired and her legal years are already on record as 27B and 27C. So far as appellant number 2 is concerned, he has expired on 11/9/2019 and the names of legal years are in paragraph 2 of the interlocutory application. Appellant number 5B has expired on 2/8/22 and the names of legal years and successors are in paragraph 3. And appellant number 29, appellant number 16 has expired on 18/4/2018, whose legal years and successors are mentioned in paragraph 4 of the interlocutory application. The learned counsel has submitted that the matter was admitted as back as in the year 1996 and the case remained pending. He further submits that the matter arises out of partition suit and has also submitted that the appellants were under the impression that the case was taken up under the heading targeted cases, and thereafter when the counsel for the appellant contacted them, the present interlocutory application seeking substitution has been filed. He submits that the delay in filing the petition for substitution be condoned, the abatement be set aside, and the substitution be allowed. The learned counsel for the respondent number.
There are many respondents.
The learned counsel for the respondents has opposed the prayer and has submitted that there is no sufficient delay, a sufficient explanation for so far as the delay is concerned. In the year 2022, also a petition for substitution was filed. However, he does not dispute that the matter arises out of the partition suit. After hearing the learned counsel for the parties and considering the fact that the appeal has remained pending since 1995 and that the matter arises out of the partition suit, the substantial question of law has already been framed. The prayer for deletion of 27A, appellant number 27A, and for substitution of appellant number 2, 5B and 16 is allowed subject to payment of cost of ₹5,000 to the. अब आप किसको देंगे?
एडवोकेट क्लर्क एसोसिएशन को दे दिया।
To the advocate clerk.
हम लोग को लेते नहीं कोर्ट की जाते हैं।
To the advocate clerk.
एडवोकेट क्लर्क को दे।
The proof of deposit should be filed within a week. At this, counsel for the appellant has submitted that the wakalatnama on behalf of the proposed legal heirs and successors has already been placed on the file. The counsel for the appellant is directed to delete the names of the apostate respondent appellants and insert the name of the legal heirs and successors as mentioned in the interlocutory application. The counsel for the appellant has also filed a fresh cost application. और क्या है इसके अलावा?
Not एक और आइए हैं, but there are few respondents who have expired. That is 13.
ये लास्ट वाला लाइन अभी नहीं, बाद में cost application से बनना. बताइए.
13,666.
Yes, who has expired?
Note respondent number 9, 13, 14, 15.
इसमें तो कोई confusion नहीं है ना?
नहीं इसमें कोई.
Respondent number 9,
13,
13,
14,
14,
15,
15,
22,
22,
29 and 30.
29 and 30.
In this note we have prayed for a direction in terms of order 22 rule 10.
आपको अपने परिवार वालों का नाम नहीं पता है?
इसमें नोट
क्या बोलना चाहते
नोट
हैं?
पार्टीशन सूट से ये रहता
It's
है.
a partition suit.
पार्टीशन सूट से
No, you do not know the names of your family members. They will give you the details. What is this?
नोट इसमें एक सेक्शन मतलब काफी पुराना है तो
पुराना
ऊपर
है
से
तो
3-4 ब्रांच है और उसमें से नोट एक ब्रांच में से कुछ लोग एक्सपायर किए हैं जो इनके पार्टी थे. अगर ये इन्फॉर्म कर हम
क्या
इसीलिए
inform कर रहे हैं?
नोट
Delay condonation का
नहीं
काम
डिले
नहीं
कंडीशन
करना. फिर
नोट
क्या?
ये हमको खाली
They are all your family members.
नोट बहुत लोग हैं जो मेरे फैमिली मेंबर्स नहीं हैं डायरेक्टली.
So in the partition suit, there are persons who are outside the family also.
Yes also because there has been sale deeds also. वो उन लोग का भी डेथ हुआ वो they are also party.
कौन consents?
Yes, but your lordship may see note the appellant is Rajat Mian. He is a Muslim. And number notes your lordship may see respondent number 14 Chandrika Nonia. So Nonia notes how can he be a family member? Then notes Dhyan Mehto, Rajkaran Mehto. So they are not my family members.
Provided he is representing in all of them. Has he entered appearance on behalf of all of them?
ये तो सब तरफ से नहीं किया।
ये तो नहीं है।
लिमिटेड हो सकती है
लिमिटेड है तो वकालतनामा वेरीफाई करना
तो वही बोला तो
इनका वकालत कुछ ही नहीं है, आप लोग को पता है किसका वकालतनामा आपके पास है, आपको ये भी नहीं पता।
बहुत ने लोग लॉट से देख कर गए हैं कि
क्या देख
पुराना
कर गए?
पुराना हमको वेरीफाई करना चाहिए, तो दिस इज आवर ड्यूटी लॉट्स, आई एम सॉरी लॉट्स।
किसकी तरफ से अपेयर हो रहे हैं ये भी नहीं पता है, तो इसके बियॉन्ड तो हम क्या ही बोल सकते।
जो नॉन मुस्लिम लोग हैं उन लोगों के बारे में हमको पता चला कि ये लोग डाल्टन में छोड़ कर दूसरी जगह चले गए,
बहुत अच्छी बात।
कुछ पता ही नहीं है इन लोगों के बारे में।
तो जो मुस्लिम लोग को बता दीजिए।
तो आपके रिलेटिव है वो तो हम
मतलब आपके रिलेटिव आपके
पता कर ही
रिलेटिव
लेंगे। ऐसा बात नहीं है, हम तो बता ही देंगे, आप भी पता करिए।
हाँ हम तो ट्राई कर ही रहे
हम भी दे देंगे आपको, मिल जाएगा तुरंत व्हाट्सएप,
यही काम हो
व्हाट्सएप कर देंगे, ऐसा थोड़ी ना है। सबका नाम सब पे तो अच्छा है।
सबकी तरफ से नहीं अपेयर कर।
सब की तरफ नहीं है।
लिखिए फर्दर आइए नंबर 1366 of 2025. This petition has been filed seeking extension of time to file petition for substitution of deceased respond number 9, 13, 14, 15, 22, 29 and 30. Even the date or year of death of these persons have not been mentioned in the individual application. The respondent number 2, 4, 13, 14 to 17, 19 to 22 and 24 to 29 have entered appearance by filing wakalatnama. The counsel for the respondents has submitted that he is not appearing on behalf of all of the aforesaid respondents whose name has been mentioned in IA number 1366 of 2025. However, so far as the respondents for whom he is appearing, he shall file an appropriate petition giving the details of the legal years and successes.
उसकी तरफ से अगर इसमें काउंसिल भी क्लियर करें ये राज नहीं करें
और कोई और किसी का कोई वकालतनामा नहीं, बाकी सब सब्स्टिट्यूटेड लोगों का है।
कोई सब्स्टिट्यूटेड लोग कहीं बोल
और तो किसी का ही नहीं इसके अलावा, कोई सब्स्टिट्यूटेड लोगों का तो कुछ है ही नहीं इसमें,
नहीं
और किसी का नहीं।
अरविंद कुमार मेहता जयप्रकाश साहू इनका भी वकालत इनके ऑफिस के अलावा
नहीं हमारे ऑफिस से नहीं है,
अरविंद को उनका सब
नहीं हमारे नहीं है, साहू जी नहीं है।
ऐसा है कि हम इसको अब कितना दिन बाद पोस्ट कर दें तब तक अबेट हो जाएगा, कुछ दिन बाद पोस्ट कर देते तब तक अबेट हो जाएगा। Therefore it is abated and we are not bothered about it. Why should we bother about it? आप लोग एक दूसरे के ऊपर रिस्पॉन्सिबिलिटी, अबेट तो हो ही जाएगा ना, वो फाइल करें चाहे ना करें, अबेट तो हो ही जाएगा, ठीक है? That would be better. Let it be abated. We don't bother.
15 minutes, 4 weeks, 10 minutes, हम इसको client को inform कर देते हैं कि it should not come upon us.
It will come upon you. करना ही पड़ेगा ना. इतना डिले से आपको सब्स्टिट्यूशन इतना रेकलेस है स्टेटमेंट सब भी कुछ कहने का नहीं. इतना रेकलेस. जब मन होता है तब आके सब्स्टिट्यूशन फाइल कर देते, डिले भी एक्सप्लेन नहीं करते, कुछ एक रीजन भी नहीं देते. किस तरह का ड्राफ्टिंग है? ये सब सब्स्टिट्यूशन रिजेक्ट करेंगे ना तो सस्टेन नहीं कर पाएगा आपको सुप्रीम कोर्ट तक. जिस तरह का ड्राफ्टिंग है पूरा कोट करते हुए इतना लेजरली, आपको ये भी नहीं, आपको पता चला ना डेथ हुआ है तो ये तो पूछते ना कब डेथ हुआ है. कोई साल तो पूछते, कोई सेंचुरी भी पूछ लेते. पिछला सेंचुरी में हुआ है कि इस सेंचुरी, क्योंकि तो पिछला सेंचुरी से केस चल रहा है ना. राइट. कोई रिस्पॉन्सिबिलिटी नहीं है.
हम लोग ने ट्रांसफर लोग 4 weeks 10 minutes उस पे अगर हो गया सब्स्टिट्यूशन लोग इन भी हम अगर इन्फॉर्म कर देंगे और जिसके तरफ से एटलीस्ट अपियर कर
तुरंत इन्फॉर्म करें, तुरंत भेज देंगे व्हाट्सएप पे.
हमने व्हाट्सएप में नहीं हम पावन पिटीशन फाइल
पोस्ट ऑन 19 दिसंबर. अच्छा, लास्ट वर्किंग डे आइए, पूरा दिन यही करेंगे 4 बजे तक. ठीक है ना.
बट 70 कर रही
नहीं
है 18 हम
नहीं हम करेंगे.
18 19
सब्स्टिट्यूशन को लेके ना रिकॉर्ड देखते हैं ना कुछ. ये आइए क्लोज कर दीजिए इसको. आइए तो क्लोज कर देना.
बट 70 कर रही है
नहीं.
18 19 हम हैं
बहुत अच्छी बात है, मत रहिए.
सर
फाइल
सिविल लिटिगेशन आप ही लोग के कारण बर्बाद हो गए झारखंड में. यू आर रिस्पॉन्सिबल. अब हमको लगता था कि हम लोग का बेंच नहीं बना, ये नहीं बना, इस वजह से नहीं बना. दैट इज नॉट द रीजन. सब्स्टिट्यूशन तक नहीं पाएंगे. और आपका 9 आई थिंक अराउंड 60% लिटिगेशन सब्स्टिट्यूशन में पेंडिंग है. 60% litigation, civil litigation is pending for substitution.
Order second Q, second appeal 88 of 1984.
Not today मतलब क्या? कब का है ये? 84. तबीयत खराब होगा. पिटीशन क्यों नहीं फाइल किया? कहाँ किए फाइल? कल के लिए रख देते हैं. रोज रखेंगे. एवरी डे दिस केस इज गोइंग टू बी लिस्टेड एवरी डे. आई थिंक दिस इज द ओल्डेस्ट केस ऑफ कंट्रोल. 84. शुक्र है 1884 का नहीं. जिस दिन नहीं आएगा ना उस दिन डिसमिस कर देंगे. 44 पक्का कर देंगे डिसमिस. इस बर्डन को हम लोग क्यों झेलें? आपका नेग्लिजेंस को हमारा कोर्ट क्यों झेलेगा? I request as a counsel for the appeal and post tomorrow. सूट कब का है? 69. 79 बढ़िया। बाकी जो भी लोग हैं सभी मर जाएंगे, कोई बच्चे का नहीं, हम लोग भी मर जाएंगे, केस जिंदा रहेगा।
Item 3, 2nd April 26 of 1998.
Before proceeding on merits, if the previous order is same. Whereby if they filed an IA, that is order number 26, dated 7/8/2025.
Yes.
They filed an IA, respondent contesting respondent, with regard to respondent number 8 that we have not taken any steps and so the appeal should have been. We filed a reply to that also. And apart from the reply, we also filed a separate IA. And we made a prayer for deleting the name of respondent number 8, giving the reasons thereof. And we also filed another IA for impleading of one of the party, and which has been taken note of by this honorable.
I'm not taking it. With respondent number 8, you have so much of stories.
If order dated 7/8/2025 is seen, where this honorable court has reported all the relevant facts, 7/8/2025. Because respondent number 8 is concerned, we have stated in our IA that actually Sumitra Devi, the daughter of Mohan Kewar, he died in 2002 only when she was minor and unmarried. And Mohan Kewar is already a party as respondent number 11 in this appeal. And so we made a prayer accordingly. And we filed, by way of abundant precaution, we filed another IA to implead one Santi Kumari, who is daughter of late Ram Prasad Kewar and wife of one Danu Kewar. Because Sumitra Devi, who is sought to be deleted, she has been named as the daughter of late Ram Prasad Kewar. To clarify that situation, we have filed this interrogatory applications, these two interrogatory applications. And therefore, they have, by the last paragraph 6 records, on our prayer and the learned counsel for the respondents, prayed to respond to the said affidavits.
But can I just simplify it? The Lordship may see yours order number 24 first. Order number 24. Let us see one by one. This is 10/6/2024. May I place it? But from the office note dated so and so, it appears that the notice was issued by ordinary process as well as registered post by IA number so and so. But order dated now notice have been duly served on all the proposed legal errors of respondent number 1, 3, 5, 6, except respondent number 8 and 9. As per service report, respondent number 8 have died and respondent number 9 could not be found. So note, on this pretext, we filed an IA, that is IA number 8023 of 24. That so far as respondent number 8 is concerned, it has been mentioned in order dated 10/6/24 that respondent number 8 has died, and therefore the appeal cannot be segregated, and therefore the entire appeal abates. And respondent number 8 is not the name of respondent number 8, the Lordship may see, is
Sumitra Devi. Sumitra Kumari.
Sumitra Kumari, minor daughter of late Ram Prasad Mathur. This is what is mentioned in the memo of appeal. Now, in response thereto, they have filed a reply, rejoinder to my IA.
Ram Prasad Mehto.
Yes.
Yes. What have they filed?
And they have filed a rejoinder to my IA, and they say कि सुमित्रा जो पार्टी बना दी है, ये गलती से बना दी है कि सुमित्रा दूसरे आदमी की डॉटर है एंड उसका जरूरत नहीं था उसको पार्टी बनाने. दिस इज व्हाट देयर स्टेटमेंट
ये कॉस्ट है कि कैसे चेंज हो?
यही तो लिखा जा रहा है. Therefore, your lordship will also have to see not title appeal का party position, क्योंकि उसमें एकदम specific लिखा होगा कि कौन है ये सुमित्रा जिनका डेथ हो गया. Just to get out of this abatement thing, they have created all this confusion. I will just show.
Where is the reply?
Yes, they have filed a rejoinder to my IA. That is on 28/2024. They have served me.
Yes. What have they mentioned?
Yes. Let us see notes. First is we have done the affidavit note para 3 onwards. Para 2 note. That it is mentioned in the order date 10/6/24 that as per the service report, the respondent number 8 has died. That therefore the prayer is being made for filing interlocutory application for deleting the name of respondent number 8, since she has not left behind any legal heir and representative. That no particular has been given of any legal heir of the respondent number 8 by respondent in their IA number so and so. That the date of death of the respondent number 8 is not mentioned in IA number so and so. That is implied to the statement made in para 3. It is stated that appellant have come to know that one Sumitra Kumari, daughter of Mohan Kewat, has died in the year 2002. Now they say कि सुमित्रा कुमारी के फादर का नाम मोहन केवट has died और पहले वाला में राम प्रसाद, your lordship see. Yes. Mohan Kewat has died in the year 2002 while she was minor and unmarried. One Mohan Kewat, son of late Hazari Kewat, is already a party as respondent number 11 in this appeal. That is implied to the statement made in para 4 of the IA. It is stated that therefore, in the aforesaid circumstances, this appeal would not abate against respondent number 8 as there is no legal representative of the deceased respondent number 8, and further the right to sue survives against other surviving respondent. The statement made in para 4 in the IA that the decree cannot be segregated and cannot be reversed in absence of respondent number 8.
So they changed the identity of Sumitra Kumari.
Exactly. Now they say कि सुमित्रा कुमारी जो है मोहन केवट की बेटी है और मोहन केवट ऑलरेडी पार्टी है, तो हमको सुमित्रा कुमारी को हम गलती से पार्टी बना दिया. Now your lordship में काइंडली सी टाइटल अपील जिससे अराइज कर रहा है सेकंड अपील.
ये फिर उसके अलावा क्या ये आइडेंटिफाई कर?
बट ये आप फाइल कर लिए कि सुमित्रा कुमारी को ऐड कर दीजिए पार्टी.
ऐड?
शांति, हाँ, एक वन टाइम का
पहले ठीक से देख ले.
हाँ.
हम लोग कहीं ये नहीं बोले हैं कि हम लोग गलती से बना दिए हैं और ऐड बोल रहे हैं शांति who is
कुछ नहीं ऐड हो सकता है. Please don't tell us all this.
If that is not required, I submitted by way of abandoned precaution. By way of abandoned precaution,
You see, the identity which you have disclosed by way of rejoinder is of a different person altogether.
Now
We will not take that as
only one thing, only for purpose of submission. They were given time because of this reason. Therefore, I refer to order number 26. They were given time to respond. They have not made any objection in writing to any of this.
Need not be.
Now, therefore, that order 26 records, they were given time to respond.
Maybe they have not responded, but we see it on the face of it.
Yes. Therefore, if at all we have made a prayer, we have filed a reply to that, and we have made a prayer to delete the name of Sumitra Devi, because Sumitra Devi was there, who was daughter of Mohan Kewat, who died in minority, living without any. There was no legal heirs, legal representatives, and therefore we have made a prayer for deleting name of Sumitra Devi. If that is considered, and then in that event we will not trace that idea because we filed it since there is no objection, so we filed it.
We will say it is abated. We will not say deleted.
Because so far as
You see, when the identity, you are disputing the identity itself.
because then it is to be shown. Then it is to be shown by them since they are raising it. They
What
are raising that objection.
You are raising that objection.
No, they have raised that objection. That it has abated. It has come up since they have raised the objection.
Even if they do not raise the objection.
Now,
If a person is dead and it is mentioned on record, the proceeding abates.
Then they have to show.
They don't need to
No,
show
only one thing
anything.
which I am submitting. It is up to this honorable court to consider. I am only submitting that then they have to show that Sumitra Devi was actually daughter of Ram Prasad Kewat and she died.
Where is the dispute on that?
But they are
Is there any dispute in the record that Sumitra Devi named person was not the daughter of Ram Prasad Kewat?
We have filed a reply to their idea.
Not here. You see, if in the trial court you have not disputed that Sumitra Devi was the son of Ram Prasad Kewat, how will you dispute it in second appeal?
as soon as it has been filed and objection raised, then we have said that actual status.
No,
we have
what
brought-
actual
we have
status?
brought on record the actual status.
Lord, we see
and now they have not filed.
degree.
Just
Appellate
let
degree
me
जो
just
party
let me allow.
mention है,
Just one.
उसको देखते हैं.
Now they have not
उससे
filed
clear.
any response in writing.
Need not. You will not be permitted to change the identity of any of the respondent by changing their father's name. Because that was never an objection raised before at any stage.
And we have not made a prayer, specific prayer for changing the father's name. We have made a prayer that since Sumitra Devi, who was there, she is dead, leaving no legal representative. So we have made a prayer
No,
for
that
deleting her
is
name.
not the
That is
prayer. You just have a look at your interlocutory application. You just look at your interlocutory application. Due to inadvertence, one Sumitra Kumari is impeached as respondent in the second appeal as a daughter of Ram Prasad Kevat.
Now only this statement your lordship will tally with the decree जिससे
No,
अपील आई है और उसमें पार्टी पोजीशन है.
We will not permit anybody to change the party position.
Exactly. उसमें पार्टी पोजीशन मेंशन है लॉर्ड्स इम्प्यून जजमेंट में और उसके डिक्री में.
You are just disputing the entire genealogy of Ram Prasad Kevat. चलो लिखिए सेकेंड अपील नंबर 26 of 1998 with bracket R. IA number 8809 of 24 has been filed seeking deletion of respondent number 8. Sumitra Kumari, minor daughter of late Ram Prasad Mehto. Ram Prasad Mehto लिखा हुआ है करेक्शन करके. Louis.
In title suit lord's judgment, she was respondent number 5B.
Ram Prasad Mehto, yes. By stating that due to inadvertence, one Sumitra Kumari has been impeached as respondent in the second appeal as daughter of Ram Prasad Kevat. And that Ram Prasad Kevat had two daughters, namely Shanti Kumar and Munni Kumari, besides his wife, namely Mausama Panwa Devi, and son, namely Sunil Kevat. It has been stated that Sumitra Kumari was the daughter of Mohan Kevat, who is already on record as respondent number 11. And therefore, a prayer has been made only for deletion of the name of respondent number 8. As respondent number 11, namely Mohan Kevat, is already on record. Correct? यही है आपका? The learned counsel for the respondents.
And we have made further pleadings about the family details in that act.
You have already mentioned that. The learned counsel for the respondents has opposed the prayer and has submitted that through this interlocutory application, the very identity of respondent number 8 is sought to be changed. by changing the name of her father and showing that she was son of respondent
Daughter.
number 11.
Daughter. Sumitra.
She was the daughter of respondent number 11. The learned counsel submits that the case, decreed that there was no dispute regarding identity of Sumitra Devi as daughter of Ram Prasad Mehta. And the identity cannot be changed. The learned counsel has submitted that the proceeding as against respondent number 8 has already abated.
And she was not the party since very beginning. In title suit degree she was 5B, and in title appeal
And
judgment
she was party since very beginning.
Yes.
In title suit she was 5B.
and in title
In
appeal
title appeal
she was respondent
she
number
was respondent number 8.
which is evident from the title suit degree
Yes.
and the judgment.
Yes.
Yes.
The learned counsel has submitted that the prayer for deletion of respondent number 8 may not be allowed. After hearing the learned counsel for the parties and going through the interlocutory application seeking deletion of respondent number 8 by stating that her father Mohan Kevat, respondent number 11, is already on record this court is of the view that the identity of respondent number 8 cannot be changed, and admittedly she has been in the record right from beginning. The simpliciter prayer for deletion is not maintainable, rather the proceeding is abated as against respondent number 8. Accordingly, IA number double 809 is disposed of by observing that the name of respondent number 8 would be deleted from the cause title, but the deletion will be on account of abatement. It is observed from the decree passed by the learned first appellate court that Sumitra Kumari and Munni Kumari both were daughters of late Ram Prasad Mehta, and Munni Kumari is now respondent number 9 in this appeal. Correct?
Yes.
हो गया आपका IA भी closed? You filed IA number?
But my IA is IA number 8023.
8023 or 24 is also closed. बताइए आप क्या बचा?
Yes, merits.
चलिए आगे.
The questions of
Look,
which
once
are
the lordship has had been, so far as respondent number 8 is concerned,
It has abated.
it has abated. So once, then your lordship will not close my IA, your lordship will pass an order on my IA.
No.
Because once it is abated, against one
The consequence of abatement
Yes.
in connection with
Will be
respondent
left.
number 8 will be considered at the time of final disposal of this case.
Right.
right? The parties have commenced their arguments on the merits. शुरू करिए.
So far as the
पहले abatement का काम शुरू करिए.
हाँ जी, so far as abatement is concerned, it is relevant for the purpose of deciding as to whether the appeal would abate as a whole or it could be the decree separately. The most relevant fact would be that the respondent number 8, this is respondent number 8, C was the defendant. It is the appeal is filed by the defendant.
Who was the original defendant? Her father or herself?
Her father.
नाम बताइए.
Her father.
नाम
As per
बताइए.
record, Ram Prasad Kewat. Her father was one of
राम प्रसाद में तो दिख रहा है. आप राम प्रसाद केवट कहाँ से बोल?
वो हाँ चेंज हुआ राम प्रसाद केवट और मन तो फिर वहाँ पर डिग्री में चेंज हुआ है.
डिग्री में कैसे ऐसे चेंज हो?
हाँ मतलब वहाँ परमिशन मिला होगा उसमें जो डिग्री हुआ डिग्री में वही लिखा हुआ माइनर डॉटर ऑफ लेट राम प्रसाद महतो जो अपीलेट डिग्री में है.
क्या नाम इनका? सावित्री ना?
सुमित्रा.
She was the original defendant. Number 5 was Ram Prasad Kevat,
Yes.
right? Original defendant number 5.
Yes.
Okay. He was substituted by 3 persons.
Yes.
One minor son and 2 minor daughters.
Yes.
And wife 4.
Mosammat Panwa Devi.
हाँ.
Wife.
He was substituted by 5 to 5C. Substitution, right?
Panwa, Sunil, Sumitra and Muni.
Wife, son, 2 minor daughters. Son was also minor. Wife is on record or she has expired? Wife का नाम है
वाइफ का नाम है
पनवा देवी. Wife is Panwa Devi.
Yes.
She is there on record or she has expired?
She's there on record in the
Panwa Devi. Respondent number 6. She is there on record.
Yes. Now on the issue of abatement, since the suit was of the respondents were the original plaintiffs, they sought for a decree. So the test of severability of the decree, because in the event
Respondents were the plaintiffs.
the respondents were the plaintiffs, the original plaintiff, the contesting respondent.
How do you say respondents were the plaintiffs?
Yes, respondent number 1 and 2.
No, title suit respondent.
Yes.
Plaintiff was one Ratan Lal Jain.
Yes, and the contesting respondents, whom learned friend is representing, they are the respondents.
So you cannot say that the respondents were the plaintiffs.
They
Might be pro forma. We do not know what was their status.
Now the issue is that the issue of abatement arises. Issue of abatement arises to avoid any legal implication that whether the decree is severable or not. Now in the event the appeal fails. The decree as reversed by the learned appellate court will stand. In that event, they will certainly be entitled for that decree. There is no doubt. In the event we succeed in the appeal, then there suit or the as modified in the appeal, that goes in the event the appeal allows. So there also there will be no question of severability of decree in both eventually, because since the situation had been different,
The suit was decreed or dismissed?
the suit was decreed. Decreed. What happened? The issues were like this. The suit was decreed by holding their
First appeal allowed.
first appeal allowed with certain modification. The suit was decreed by holding their title document which they were claiming, a sada salary, to be valid, and by denying the relief of adverse possession. And we moved in appeal. In appeal, their title document was not considered to be illegal. The appellate court reversed to that extent that the title document is not legal, it is not valid, since it contravenes section 46 of the Jharkhand Tenancy Act, and on that score, the suit judgment was modified, but the findings were kept as it is for the reason that the learned appellate court came to a finding that they have perfected their title by adverse possession. Now the learned appellate court's judgment, which would form part of the decree as of now, is on basis of prescription by adverse possession, only on that basis. And therefore the questions of law has been accordingly.
Whose adverse possession has been declared?
There, the original plaintiffs.
That is only one plaintiff.
Yes, only one. Subsequently, they died and their legal heirs as per the original plaintiff.
Who are the legal heirs of original plaintiff?
Ratan Lal Jain,
Yes.
he was the original plaintiff.
Yes.
Ratan Lal Jain, and
There
then
is only one plaintiff. How is Ratan Lal Jain related to this respondent number 8?
they are not related.
They,
They are not related.
why are they party? They are only pro forma parties.
They are pro forma party because they were all co-defendant along with the present appellants.
Why they were made co-defendants? Is there any right of their involved in the case?
Since they were parties, they are of all the same family, same general.
Respondent number 6 belongs to the family of Ratan Lal Jain.
No, not
They-
Ratan Lal. They were all co-defendants. They were all co-defendants.
Co-defendant is another thing. You said that first you said that respondent number 6 was the plaintiff.
No,
That is
I
not
did
there.
say.
Then you said that respondent number 8 was the pro forma defendant. So I just want to know, if they are
Yes.
pro forma defendant, why have been they
If
made party?
this honorable court kindly takes the plaint for a moment, the record is there, the plaint for a moment, that will.
Plain.
All the defendants.
So how the decree is severable?
Because so far as the suit is concerned, the suit was not filed by the deceased defendant. The suit was not filed. She did not sought for a decree. And in the event the appeal succeeds, meaning thereby the suit fails. So then there would be no question of any enforcement of any decree or something. So there would be no question of severability in that event. If the appeal succeeds, and even if the appeal fails, then also appeal fails, the decree will be there of the original plaintiff or his surviving legal representatives. The deceased has no concern with that. She will not be a decree holder along with the original plaintiff.
No, I don't understand.
If this time,
Merely because this respondent number 8 is not a co-plaintiff. Does that mean that the proceeding will not abate?
because
Her
the-
rights has crystallized. Simple.
No, because the adjudication, the purpose of suit was for adjudicating the rights as claimed by the original plaintiff. And
Why were these persons made party?
yes, if the plaintiff is seen for a moment, the very first page, title suit 47 of 92. That is one Ratan Lal Jain and then one Gulabi Devi. And the defendants includes
Gulabi Devi, number 2.
they were the
Two plaintiffs.
and all other the defendants from 1 to 12, they were all defendants. including Ram Prasad Kevat. And the relief was sought for only in respect of the plaintiffs, not in respect of any of the.
What do you mean? Relief is always in connection
Yeah,
with the
I-
property
for the-
when there is a contesting defendant.
For the purpose of abatement, I am making this submission for the
Yes.
purpose of abatement.
Yes.
Because whether the abatement of this appeal against the respondent number 8 would have any impact on the adjudication process or on the status of this
If
second.
the right of the respondent number 8 is crystallized, then under such
Because no right is declared so far as the defendants are concerned.
once your right is dismissed, right? The suit was dismissed.
No, the suit was decreed in their
The
favor.
suit was decreed,
Yes.
right? And the appeal was allowed.
Appeal,
Appeal was also not dismissed.
no, appeal was filed by us. Appeal was allowed affirming finding on the title, but setting aside the finding so far as the title document is concerned, affirming the finding on title on basis of adverse position, the appeal is concerned. So the
The defendants they claimed adverse possession.
no plaintiff.
Plaintiff claimed adverse
Plaintiff claim. Plaintiff relied on certain title document, a sada deed, which was considered by the first court, and first court relied upon that deed and decreed the suit. And simultaneously, first court also considered their plea of adverse position and said that if there is no occasion for adverse position, the learned appellate court, upon discussion, finds that the title document is not legal, is not considerable, it does not give any title, but they have perfected their right on basis of adverse position on basis of that illegal setting. That is the finding of the learned appellate. So the purpose of making this submission is that no right as such of the deceased respondent number 8 or her successor in interest was ever asserted or crystallized in the proceedings. So her death or abatement, so far as abatement of the proceeding against her would not make any difference. Had she been a plaintiff, then things would have been otherwise. Then the question would have arisen whether the decree is severable or it is one and same. That is the submission on the issue of abatement. That it will not make any difference. Because the issue of abatement would be relevant particularly where there is a decree in favor of one of the party who has died, or if more so if it is a partisan suit, where everyone has a crystallized right.
With the continue.
Yes. Now may I cover merits?
With respect to the point as to whether the entire appeal would stand abated on account of non-substitution of respondent number 8, the learned counsel for the appellant has submitted that that no right of respondent number 8 as such is involved in this case, and there has been no adjudication with respect to the right of respondent number 8. he has also submitted that that Ram Prasad Kevat was the original defendant number 5, and upon his death he was substituted by his wife, 2 minor daughters and 1 minor son. Son was also minor.
Yes. The first step.
The other minor daughter is respondent number 8, respondent number 9, the wife of Ram Prasad Kevat is respondent number 6, and Sunil Kevat, son of Ram Prasad Kevat, has been expunged by order dated 8/2/23. By stating that legal heirs 8/2/23. By stating that the legal heirs are already on record. By stating that respondent number 7 died unmarried and issueless on 12/6/2008. उसके बारे में ये नहीं बोले that they are already on record. As per this order, you simply said that the son died issueless and therefore he should be deleted. You did not say that his mother, his sisters are already on record.
Because we were.
They will not succeed.
No,
They are not the legal
No,
heirs.
this is record. We were saying since our case before this honorable court, by way of this reply was that Sumitra was not daughter of Ram Prasad Kevat, therefore we could not say.
Mother was there.
No, since we are saying.
Mother was there on record.
No, that is as per record that is there. But as per us, mother she is wife of Ram Prasad Kevat, and we are saying that Sumitra is daughter of Mohan. Therefore, we cannot say that. Simultaneously, we cannot say those things. We should be contrary because we are saying that Sumitra was daughter of Mohan.
He was deleted by stating that he died issueless. So, after the refusal of substitution or deletion of respondent number 8, by stating that she was son of respondent, she was daughter of respondent number 11, do you want to say that you can't say that her status was daughter of respondent number 11? That you will not be able to say.
Now that is closed already.
That is already closed.
Already honorable court has
Now, do you
considered.
want to say that respondent number 8, her estate is represented by the other respondents already on record? Because her sister is also there, her mother is also there.
They are already on record. As per the records of these proceedings, they are already on record, and they are representing her state, and even otherwise, since this is a proceeding where no right has been crystallized of the defendant.
That I have already
Yes. That is the main thing which we are saying. And alternatively, our submission on the issue of abutment would be that even as per the records of these proceedings, 8 did not leave any. She died unmarried. She did not leave any legal
8
representation.
के बारे में तो ऐसा कुछ नहीं लिखे हैं. That is not the statement.
नहीं 8 के बारे में हम लिख रहे हैं ना कि one सुमित्रा देवी daughter of मोहन केवट.
She died issueless.
हाँ she died.
Issueless में कहाँ लिखे?
Mine has been stated.
You have said that respondent number 11 is already there.
हाँ.
Where have you stated that she died issueless?
नहीं वो भी
Anyway, उसका तो कोई मतलब ही नहीं है
नहीं
because you are
नहीं,
disputing that.
वो हम लोगों ने लिखा है.
the learned counsel has submitted that the defendants had filed common written statement,
Yes.
and after death of Ram Prasad Khewat, his legal heirs were substituted. Therefore, death of one of the legal heirs of Ram Prasad Khewat will not have the effect of abating the entire proceedings. ठीक है? चलिए, और आगे मेरी.
Yes. And our main leave of submission was that since she was not the plaintiff, no right has been declared in her favor. So there is no question of
That I have already
yes,
said.
because the issue comes up.
Please
effect-
don't repeat. I have already
No, I
read.
am saying conflicting decree. Conflicting decree. So here it will not come an issue of conflicting decree since she was not claiming anything from the court. Now coming to the merits of this. The suit as it was filed, the relief was sought for. I am just reading the relief portion of the suit from the plea.
First you place a substantial question.
Yes, the substantial question of law, that is order dated, that is order number 4, dated 5/8/98.
Yes, please.
Whether in absence of any finding of adverse position by the trial court, the lower appellate court could have given a finding that the plaintiffs had acquired right, title and interest by adverse position. Whether in absence of any finding of adverse position by the trial court, the lower appellate court could have given a finding that the plaintiffs had acquired right, title and interest by adverse position.
Next substantial question.
Yes. Whether the learned lower appellate court has committed an error of law by not deciding the issue number 8 framed in the trial court in its true perspective. Issue
What
number
was
8
issue number 8?
regarding adverse position. Regarding adverse position. Then C is
No, I don't get it. What is the substantial question of number 8?
yes, whether the learned lower appellate court has committed an error of law in not deciding the issue number 8 framed in the trial court in its true perspective.
So, issue number 8 has already been decided. That is by a finding of adverse possession.
Issue number 8, therefore, this
It was not in true perspective.
yes, that is
So, A and B goes together.
together. That was perhaps the intent of this honorable court, whether it has been decided
Third
properly.
one.
Whether the findings of both the courts below regarding the right, title, and interest in favor of plaintiffs on the basis of Exhibit 2 and 2A are erroneous.
What is exhibit 2 and 2 by A?
So
The
whereas
court has declared the title and adverse possession both.
first court declared title, denied adverse possession. Second court denied title on basis of title document, but declared title on basis of adverse possession.
What is exhibit 2 and 2 by A?
Yes, Exhibit 2 and 2 by A. These are the cell deeds which are being relied by them,
By whom?
by the plaintiffs.
Once the title is declared, what is the point of deciding adverse possession? If
Because
the title of the plaintiff is declared, then it is irrelevant.
there was an issue. So on that,
It is irrelevant, completely irrelevant.
I will show that in what manner it has been
Because
decided.
there is a concurrent finding on title.
Not concurrent. The first court says that the cell deed is reliable, that the cell deed is a legal document. Second court says cell deed is illegal.
Okay.
Then
Then by point number C is whether the finding of both the courts will.
in
It seems that it is concurrent finding.
no, I will just show that.
No, what does this mean? Let us see this question. Let us understand the question of law.
Yes.
When finding of both the courts below regarding right, title and interest in favor of the plaintiff on the basis of exhibit 2 and 2 by A is
Because
erroneous.
this has been because of the reason that the second court relies on those illegal cell deeds, saying that though the cell deeds are illegal, that is a definite finding of the learned first court, that the cell deeds are illegal, but continuing in possession on basis of illegal cell deed makes that possession perfect by prescription of adverse possession. And therefore, this honorable court has.
No, It is still covered by 1 and 2.
In a manner, it can be said that it is correlated.
It is, you see, both the codes giving finding with respect to exhibit 2 and 2 by A. You
Because-
say that both are erroneous, so there has to be some concurrent finding to say that both are incorrect.
So, concurrent in the sense, only concurrent is that the second code also says, yes, they have perfected their title but by adverse possession. And in that sense, this honorable court has perhaps framed issue numbers, question of law.
And issue question of law number D is whether both could be decided. Whether both could be decided.
Because the main issue would be before this court. Now the first court's judgment is modified, the learned first court's judgment. And the second court's judgment which is there, it is only on basis of adverse possession. So only that, perhaps all these issues, perhaps the main issue as per the issue number A to C, as rightly pointed out by the honorable court, A to C, it are more or less related. Now the main thing which has to be seen as to whether the finding of adverse possession is proper, as it has been also in its true perspective, issue number second is proper, and it is in accordance with the principles on basis of which a finding of adverse possession can be given. A party can be said to be
So, adverse possession is declared from which date?
the adverse, so far as the date is concerned, the date is taken to be the 28th cell date, the 28th Sada cell date, on that basis.
And SATA sale deed has been held to be invalid on what basis? On for want of registration.
Yes. And want of registration and another thing was there, that was executed by a party on basis of a Dar Rayati title. Dar Rayati
That does not is not transferred.
Yes, not transfer.
Let us see the plain remedies.
Yes. Now, to the question of law, let the relief sought for. Para 24 is in the relief which is sought for.
We will see the plain because we are on adverse possession. We have to
Yes,
see
yes.
basic foundational
yes.
pleadings and everything.
Yes. The plaintiffs, our first para that they have settled relief. Plaintiff, though being his youngest son, Chavanda, custom prevailing was adopted during his childhood by his uncle Sugantan, and the issue and since when the plaintiff became the adopted son of Sugantan Jain and is living and doing all his business as son of Sugantan Jain. That the common ancestor of the plaintiff was one Goindram Seth, who died long before the last marital ceremony and settlement of business, leaving behind 4 sons, namely Ashutram Seth, Ramchandra Seth, Kaspurchand Seth, and Champalal Seth. Out of whom the branches of Ramchandra Seth and Kaspurchand Seth extinguished, as would appear from the genealogical table appended for this date. Ram Seth died leaving behind a son, Manmal Seth, who also died leaving behind 3 sons, namely Sankarchand Jain, Gyanchand Jain, and Dhanuchand Jain. In the same manner, Champalal Seth also died leaving behind 5 sons, Chogalal Seth, Suman Chand Jain, Gorilal Jain, Kaushalan Jain, and Kulchand Jain, out of which 2 sons, Shodarmal and Nagamal Jain, who have now been shifted to village Patron, and third son, Ratnalan Jain, the plaintiff, was adopted by his uncle, Suganchan Jain, who also died leaving behind the plaintiff as his sole legal surviving heir and successor. The third son, Gorilal, is still alive, whereas Kaushalan Jain also died leaving behind the son, Rajkumar Jain, and Kulchand Jain is still alive. The relationship of plaintiff with common ancestor will appear to the genealogical table and the fruit of the claim, which will be treated as part of the claim. Then comes the story about the plot, para 5, that Khata number 407 consisting of 4 plots, total measuring an area of 1 acre 2 decimals, including of plot numbers 3767, area 0.32 acres. Soon after the final publication of records of life, Madhu Kewat died, leaving behind 3 sons, Meghlal Kewat, Sivdayal Kewat, and Lakshman Kewat, who came in joint possession over the lands recorded under Khata number 407 and subsequently partitioned the same amicably sometime in the year 1906. That thereafter the three brothers started to deal with the lands recorded under Khata 407 separately, and in process to that, Meghlal Kewar, son of Madhu Kewar, being in separate possession of 0.11 acres in plot 3767 towards the western part of the opposite plot, settled in permanent Dar Rahiyati, measuring an area of 0.11 acres out of 0.32 acres in plot 37 by executing a deed of Dar Rahiyati in favor of Laldev Chaudhary, son of Ramsaran Chaudhary, dated 19/6/2019, which is butted and bounded as follows. The boundaries are given, not true, that's how the government is remaining portion of electrical and rest. And put the settling in caste position. That is settling is that right. Laldev Chaudhary, in exercise of his right title interest position, constructed a residential house aforesaid to Saram Gomia Road, shown in green color on map with name, and in land out of 11 acres, and rest land out of 11 decimals was converted to a body land to the knowledge of everybody, including Siddhyal Kewar and Lakshman Kewar. This is about the right. That Laldev Chaudhary, further in exercise of his right title interest possession, transferred the aforesaid land measuring an area of 11 decimals, including the tiled house standing therein, by a registered deed of absolute sale dated 28/5/28, jointly in favor of Harshud Ram Seth and Champalal Seth, and put them in caste possession thereof. That Harshud Ram Seth and Champalal Seth, in exercise of their right title interest, jointly, along with their brother, started to surround the aforesaid land by raising compound wall made of stone boulders and earth, and when the same was objected by the legal heirs of Madhu.
Kindly read this paragraph once again.
Para
10.
9.
Para 10.
Okay. That Harshud Ram Seth and Champalal Seth, in exercise of their right title interest and possession, jointly along with their brother, started to surround the aforesaid boundary, raising compound wall made of stone boulders and earth. And when the same was objected by the legal heirs of Madhu Kewar, which ended in compromise, whereby it was decided, it is very important, that Laldev Chaudhary, their vendor, Laldev Chaudhary shall surrender the land to the setter, who shall transfer the same in favor of Ramchandra Seth, son of Govind Ram Seth, and Gulab Chand Seth, son of Ramchandra Seth. And accordingly, by a deed of surrender dated 3/7/28, executed by Laldev Chaudhary on a stamp paper of 8 annas, surrendered his right to Meghlal Kewar, who in turn, measuring an area of 11 decimals in favor of Ramchandra Seth and Gulab Chand Seth, on receipt of cash consideration of ₹45, by executing a sale deed on a revenue stamp of 1 anna dated 7/7/28. Now comes this Sada sale deed. This is the basis of their title, because they themselves say that the registered sale deed goes, it was by the Dar Rahiyat, then they say there was arrangement, Dar Rahiyat would revert it to the original Rahiyat, that is Madhu Kewar, and then they say that Madhu Kewar executed this 7/7/28 deed, which is a Sada deed. This is arbitrated, and allowed the said purchaser besides Harshud Lal Seth and Champalal Seth to continue in possession thereof, who accordingly surrounded the same by raising compound wall and made of stone boulders, earth and sand, and the same is still in existence, which can be verified by local inspection. The aforesaid
So
land
you came in possession by virtue of this particular Sada deed.
they claim.
They,
They claim.
they came in possession.
Yes. They, by this Sada deed. Yes. That is their case. About 11 decimals.
And this is a suit property also.
Suit there, I will just show from the deed. They sought for relief with respect of this main property, suit property, and then part of this also. First relief has been denied.
Part must be for recovery.
No, for declaration and recovery also. 104 square meters, square feet. That part. And first relief has been denied to them. First part. No relief has been. Only that part relief has been granted. 104 square feet. Now, this 10 is there, then 11 comes.
So 12 years commences from expired on 27/5/1940, and then you say that you continue to remain in possession, and therefore
This.
this and therefore they have perfected the right title and interest in connection with the property.
And on that we have our legal pleas that will, that so far as there cannot be mutually exclusive pleas, on the other hand claiming title, and the other side saying that by adverse possession. That is one thing. And on that we will also assert the learned appellate court judgment saying that even the illegal document will not allow the possessor on basis of illegal document will not amount to adverse possession. Then paragraph 11. They say that as well as not
Adverse possession will come when you exercise your right as a true owner of the property
Yes, yes, and not admitting
and
either.
deny the title of the other
Yes.
side.
And that is missing here because that is rather they admit the title. They admit the title which is paragraph 5 also. And they admit that they have got a sell deed, sada sell deed from the true owner. So they admit the true owner, they are the very first prerequisite of adverse possession that is missing in this case. And which has perhaps not been appreciated by the learned first appellate.
First requisite is what? What are the requisites?
Yes, there are three things which we commonly say. That is adequate in publicity, adverse to a competitor, and adequate in continuity. Which we commonly say ni claim, ni preferio, and nec we. Three things. If someone is saying or admitting the other person to be the true owner, and then there cannot be a claim for adverse possession, so far as that part is concerned.
You prayed for adjudication of title. The plaintiff prayed for adjudication of title with respect to Schedule B. They wanted khas possession through process of court with respect to Schedule B.
Yes.
Then they wanted injunction
Yes.
with respect to Schedule A.
Yes.
Schedule B is a part of Schedule A.
Yes. The schedule that is just there. Schedule A includes. Schedule A has two items. Just I will first read the schedule and then schedule A has item 1. They say 10 decimals of land. Khata 407.376. Area 0.10 acres. As described earlier. Then item 2 is 11 decimals. So item 1 is included in item 2 of schedule A. And then comes schedule B after their boundary.
Item 1 is included in item 2.
Yes.
No?
It is.
Is it a part of item 2?
Yes.
Or it is in addition to
No, it is part. From their conjoint reading of the pleadings, it is apparent. Because they are making only claim over only 11 decimals by virtue of that 1928. That is. And then schedule B. Schedule A, they have not got any relief. Schedule B, land measuring an area of 104 square feet out of 10 decimals within item 1, which lies within item 1. Described in schedule A referred above, shown on the map in red.
they are seeking recovery of Schedule B.
Yes. So they have been, so but the suit is declared only to this extent. By the first court.
Naturally, they were in possession with respect to the rest of the property.
Yes, and rest of the property.
You see, the adverse possession has been declared with respect to entire Schedule A property,
No.
only with respect to Schedule B
Schedule B.
property.
Yes. It is their relief A has been denied. Their relief A, the first relief they sought for, page 14 of the plan.
I read the
Page 14 of the plan.
findings.
Yes.
Was the trial court or you want to leave that?
Trial court would be necessary because the issues
What was the case of the defendant?
we denied so far as the partition is concerned. We denied the partition, and we specifically reverted their plea of possession and so far execution of the secrets. We specifically denied. And their whole case was based that there was amicable partition, and on that basis that's another reason. May I read out from the issues given by the learned first court?
Yes. You read out your case before you go.
Yes.
Para 5 of the trial court
Yes.
judgment. Or you can come straight to the issues. There is no.
The issues are first one is maintainable in its present form. Second is bad for disjointer, non-jointer. Third is valid cause of action. Fourth is barred by law of limitation. Fifth is study of adoption of plaintiff won by Sudan Lal Jain is valid.
It is at page number?
Internal page 10. The top of the page.
Internal post.
Yes.
The AC one particular post.
Internal page.
Yes. Read it. 6, 7 minutes.
Yes, 6, 7, 8. Whether Laldev Chaudhary transferred Darayati interest for the land of item 1 of Schedule A land of the plaintiff, including suit land to Champalan Jain and Harshuk Ram Singh. 7. Whether the story of transfer of the land of item number 1 of Schedule A of the plaintiff, including suit land by Meghlal Kewat to Ramchandra Kewat Seth and
Why is it mentioning including Suitland?
Schedule A of the plaintiff. Item 1 schedule of the plaintiff, including suit land by Meghlal Kewat.
Why is it mentioning including Suitland? Suitland is what? Schedule A and B both?
As per them, it was both, but as they did not pay court fees, and therefore that relief has also been denied to them, which I will read out from the findings. Whether the story of transfer of the land of item number 1 of Schedule A of the plaintiff, including suit land by Meghlal Kewat is genuine, correct and valid, then 8 is whether Harshuk Ram Seth and Champalal Seth acquired the title by adverse possession over item 1 of Schedule A land of the plaintiff, including the suit land. And then valid title.
So item 1 is
That is 10 decimals. Item 1 is 10 decimals, item 2 is 11 decimals.
so they are all these are concerned with item 1,
Yes.
not with item 2.
No. Which is under Schedule A of their plate.
Can you read?
These issues are taken up together, 6, 7, because they are correlated and most important of other issues. The plaintiff has examined altogether 10 witnesses in the PW1 Virendra Prasad, PW2 Santosh Kumar Jaswal, PW3 Nandkishore Pathak, PW4.
That's right.
Yes.
See.
And then PW1 to 3 are formal witness, correct. PW1 has proved the government rent receipt which has been marked as exhibit 1 to 1F. PW2 has also proved rent receipt of government which have been marked exhibit 1J to 1L. PW3 has also proved government rent receipt marked exhibit 1M to 1Q. PW9 is plaintiff himself. He has fully corroborated the facts as stated in the pleading of the plaintiff. He has stated that he is the youngest son of Shogalal alias Shogalal Jain, but in his childhood was adopted by his uncle Sugan Jain. After adoption, he started living with Sugan Jain as his son and also looking after his business. He has stated that Mohit Ram Jain was great grandfather. He had 4 sons, namely Harshuk Ram Seth, Champal, Kasturi Chand, and Ramchandra Jain. They all have died. Harshuk Ram Seth had 1 son, namely Amal Jain, who had 3 sons, namely Shankar Lal, Kanpur, and Ramchand Jain. Champalal had 5 sons, namely Shobha, Charan Lal, Suganchan Jain, Gauri Lal, Kulchand Jain, and Panchulal Jain. Shogalal Jain had 3 sons, including PW9, who was given in adoption by him, and other 2 sons were Sagarmal Jain and Nagarmal Jain. Suganchan Jain died living behind the plaintiff, and Panchulal died living behind his son Rajkumar. He has further said that the disputed land is under Khana number 407, the area of which is 1 acre 2 decimals, consisting 4 plots, which is recorded in the survey Khatian in the name of Madhu Kevat, who died after 7-8 years after survey operation. He had 3 sons, namely Meghlal Kevat, Lakshman Kevat, and Shivdeval Kevat. After the death of father, all the 3 brothers came in joint possession of the land held by him, and after 1 or 2 years, all of them partitioned the properties among themselves amicably and started cultivating the land in their possession separately. The disputed plot is within plot number 3767, with total area is 0.32 decimals, out of which suit land is only 104 square feet. In the disputed land, all the 3 sons of Madhu Kevat had share, but Meghlal Kevat sold land of his share to Laldev Chaudhary by permanent Darrayati deed in the year 1990, consisting of total area 11 decimals. Laldev Chaudhary constructed a mud house of 2 rooms with title force on some portion of the land, and rest was used as body land. Said Laldev Chaudhary in the year 28 sold the said land and house to Harshuk Ram and Champalal Seth and gave them possession. Harshuk Das and Champalal started giving boundary wall of stone borders, but the family members of Kevat objected, and in compromise it was decided that Laldev Chaudhary will surrender the land to Meghlal Kevat, and then Meghlal Kevat will execute the sale deed in favor of Ramchandra Seth and Gulab Chand Seth. As per compromise, Laldev Chaudhary in the year 1928 surrendered the land to Meghlal Kevat. Meghlal Kevat then sold the land by the deed on plain paper of revenue stamp of 1 anna to Ramchandra Seth and Gulab Chand Seth for a valuable consideration of 45, and thereafter they came in possession of the land. Then Champalal Seth and Gulab Chand Seth, Suganchan Seth and Gaurilal Seth surrendered the land surrounded the land by
it's the same thing that we have read in the plaint.
Yes.
Everything is the same.
Yes. That's in chief the same thing they have stated. Then the last
Where is the finding?
and the last part 4 lines I read it from the cross examination is there. It's the same page 12. Last part 4 lines. Now, in cross examination, he has stated that amongst his ancestors, partition was done about 25 years ago. No paper was prepared. Thus, PW9 has fully supported the material fact as stated in their plaint. There does not appear any material contradiction in this testimony. Then PW5. Should I skip and come to the statement of the findings?
Yes, you come to the findings.
Yes. Page 40. Their discussion of the documents are there. Should I read it?
Page 14.
Yes, paragraph 9. Now coming to documentary evidence, I find that plaintiff have filed a series of receipts marked as exhibit 1 to 1P and exhibit 3 and 4 series, which are receipts right from creator of Jamabandi and to vesting of Jamabandi to the state of Bihar. Earlier receipts.
You come to the bottom. I find.
Yes.
From the perusal of the documents.
From perusal of documents, I find that the land was originally recorded in the name of Madhu Kevat. The land bearing plot 3767, Khata 407, which was recorded in the name of Madhu Kevat in the survey Khatian, was sold to one Laldev Chaudhary on Darrayat. But the said Laldev Chaudhary sold the said land in the year 1928. Exhibit 2 by A also corroborates this fact, this sale deed. Exhibit 2 shows that Laldev Chaudhary surrendered the land on 3/7/28 of plot 3767 to Meghlal Kevat. Exhibit 2C shows that Meghlal Kewar sold the land to Gulab Chand Seth and Ramchandra Seth on 7/12/28 for a valuable consideration of ₹45 by executing sale.
No, kindly come again.
Yes.
But Laldev Chaudhary sold the same land to Seth.
Ashok Seth and Champalal Seth in the year 1920.
1920.
Yes.
Okay.
This was one registered sale deed.
Yes. Exhibit 2 by A.
A. Also, yes, that is Exhibit 2 by A. Also corroborates this fact. Then Exhibit 2 shows that Seth Laldev Chaudhary surrendered the land on 3/7/28. After that sale, this surrender was made of plot 3767 to Meghlal Kewar. Then the recorded tenants here. Then Exhibit 2C shows that Meghlal Kewar sold the land to Gulab Chand Seth and Ramchandra Seth 2C on 7/12/28. There's a Sada sale deed for a valuable consideration of ₹45 by executing sale deed on a plain paper of 1 anna's revenue stamp. Then comes Exhibit 2D, shows that Lakshman Kewar sold the land to Chagan Lal Jain of plot number 3767 on 3/2/41. This deed has nothing to do with the present suit, so but this 41 deed is concerned. Exhibit 2D shows that Banwari Kewar and Kartik Kewar sold land to Ghisi Lal Jain of plot 3767 bearing 11 decimals in the year 1941. Same 280. Exhibit 7, which is the order of Circle Officer Gomia, also shows that the suit plot bearing plot 3767 is in possession of the plaintiff and the defendants have no possession of right in the suit plot number 3767. Exhibit 7 by A, which is the order of the executive magistrate in case number 1285, also shows that on plot number 3767 there is possession of the plaintiff and the defendants are not in possession of at all on the suit plot. Exhibit 8 is the certified copy of Register 2, which shows that the suit plot is in possession of Champalan and Gulab Chand Seth and Ramchandra Seth. Thus, all the aforesaid documents goes to show that the suit land purchased by the ancestors of the plaintiff from one Laldev Chaudhary, who was Darraiya of Meghlal Kewar, but later on the objection of Meghlal, Laldev Chaudhary surrendered the land to him and then he sold the same to the ancestors of the plaintiff. Subsequently, the ancestors of the plaintiffs also purchased 11 decimals of land from Lakshman Kewar and some portion of plot Etna was purchased by Gesilal from Kartik Kewar and Badman Kewar. These are other lands, these subsequently part. Various rent receipts right from the period of Jamindari and also after vesting of Jamindari to the state proves the possession of the plaintiff and his ancestor on the suit land. Certified copy of Register 2 also shows the title and interest of ancestors of plaintiff on the suit land. The order of executive magistrate in a proceeding under section 145 and order of CO Bumia filed by defendants also proves the possession of the plaintiffs on the suit land. Thus, I find that plaintiff has by both documentary and oral evidence proved his title and possession over the suit land. Of course, the plaintiff have not produced any documentary evidence to prove partition amongst the heirs of Madhu Kewar, but various sale deeds executed by heirs of Madhu Kewar, that is Meghlal Kewar, Lakshman Kewar, Banwari Kewar and Kartik Kewar, who are sons of Sidwal Kewar, goes to show that that they were in possession of the respective share of land, and it shows that there was partition in the family of Madhu Kewar. After his death, and respective share holders sold the land of their respective share to different vendors. Thus, the plaintiffs have proved his title and possession and ownership on the suit land by both documentary and oral evidences. Various PWs have also proved that defendants have encroached upon some portion of the suit land, although some portion of the suit land, although they have no title, some portion of the suit land, although they have no title or possession upon the suit land. Then there is this about discussion of our evidences. Para 10.
Then the finding, come to the finding.
Yes. That is. It could be. Page 17. page 17 in the middle portion, we find it from the aforesaid discussion. I think 13th line from the top, page 17.
Yes, I'm not recalling.
From the aforesaid discussion, I find that the defendants have claimed their ownership and title on the suit land, but relating to their ownership and title, they have not produced any documentary evidence. In first place, they have stated that Madhu Gewar died in the year 1942, but no documentary proof has been produced regarding his death. The plaintiffs have also not produced any document to show the year of death of Madhu Gewar. But according to the defendants, Madhu Gewar died after the death of Meglal Gewar and Sivdawal Gewar, and during his lifetime, his sons have got no right to sell the suit land because they all brothers were co-parcener, and there was no partition in the family. But to counter the statement of the defendants, the plaintiffs have filed Exhibit 6B, which is the written statement filed by the defendants in case number 1285 under section 145 CRPC. It is stated in para 2 that Khata 407 was recorded in last cadastral survey in name of Madhu Gewar, who died leaving behind his three sons, namely Meglal Gewar, Sindhya and Lakshman Gewar. Thus, the statement made in the pleading and also supported by DWs, Madhu Gewar died after the death of two sons, namely Sivdawal and Lakshman Gewar, is falsified. From Exhibit 6B, it is clear that Madhu Gewar died leaving behind three sons. In Exhibit 6B, it is also there that Meglal Gewar died leaving behind Sivdawal Gewar and Lakshman Gewar, and Sivdawal Gewar died leaving behind their sons. This fact has also been falsified by the defendant in written statement that Meglal Gewar died after the death of Sivdawal Gewar. In fact, this statement of the defendant in Exhibit C demolishes the entire case of the defendants. This falsifies that Madhu Gewar died after death of his two sons, namely Meglal and Sivdawal Gewar, and therefore, thereafter Meglal Gewar died after the death of Sivdawal Gewar. This makes the evidence of DW7 totally false and unreliable. The defendants have already failed to produce any documentary evidence to show their title ownership on the suit land regarding issuance of rent receipt. DW7 has stated that it was issued in the name of their ancestors and also in the name, their names, but no rent receipts have been produced. In examination appeal, DW7 has stated that it was lost when census for the land was taken. But in cross-examination, he has said that it was eaten by white ant. Therefore, on this point, testimony of DW7 is rejected. On the point of possession, the defendants have first of all stated that the suit land, Maut Ka Kuan, Hard and Drama Party was held. But the statement of DW is very contradictory on this point. DW 1, 2, 4 and 5 are all aged about 65 to 70 years. But their testimonies are contradictory in this point. DW4 has stated that Drama Party was held when he was 16 years. DW5
There
has
is no flow in the judgment. Absolutely discrete.
yes.
There is no flow. कोई coherence ही नहीं है judgment में.
And then the main finding.
Paragraph 13.
Yes, sir.
Rather, you read paragraph 13 and 14.
Yes.
I think that should suffice.
Yes, page 24. Further, it has been contended that there is no evidence that delivery of possession was given to the plaintiff's ancestor or they ever came in physical possession over the land. He has further said that when the transfer is in contravention of the provision of law, then the plaintiff will not acquire right of prior. It has been stated that long possession does not mean adverse possession. It has also been said that Jabandi creates no title and it is for fiscal purpose. It has also been contended that Khatian has not been produced by the plaintiff. The Landed Defence Council has cited ruling of 1994 Supreme Court page 18 and the Landed Defence Council and 1959 BLJ 410. But in my view, contentions of the Landed Council is not tenable and the rulings cited are not applicable in this case. In the first place, there is no question of adverse possession because title is passed on the ancestors of the plaintiffs by virtue of sale deeds. executed by the ancestors of the defendants. Since the cell deeds executed by Meglal Kewar by Lakshman Kewar has acquired legal force in view of Article 19(1)(f) of the Constitution of India. Further, the plaintiff has proved the possession of the suit land by various original and documentary evidences. All the PWs have stated that the suit land is possession of plaintiff. The various rent receipt and registered to also prove possession of the plaintiff's on suit land. The order passed by CEO Bhumi and executive magistrate in proceeding under section 145 says this also prove possession. Registered to also prove possession. Of course, Jamati does not create title, but certainly it is corroborative evidence when the title of and possession of the plaintiff has been proved by other various means. The testimony of PWs that the plaintiff's ancestors have also laid out a portion of the suit land to various tenants also proves continuous possession of the plaintiff and their ancestors on the suit land. Continuous possession has also been proved by registered to various rent receipts issued are more than 30 years back. Therefore, the plaintiff has certainly got long possession, and even if it does not mean adverse possession, but certainly the land was in continuous possession of the plaintiff, corroborates the title, which has also already been proved by other documentary evidences. Thus, from the facts and circumstances, I find that plaintiff has proved his title and possession of the suit land, and defendants have not been able to prove their possession and title with respect to the suit land. The plaintiffs have got long and continuous possession with having full title and ownership of the suit land. The plaintiff has also proved that Laldev Chaudhary transferred the rayati of schedule of the plaintiff, including suit land, to Champalal and Harun Singh. Of course, the deed executed by Laldev Chaudhary excludes the land of building constructed by him, but the language of the deed shows that he transferred land mentioned in schedule of the plaintiff to the plaintiff's ancestors. It has been mentioned in the deed that he sold building including Sahan, Aguara, Chaukat, Tiwadi, including Chajan, Bans, Kapada, etc. to the vendee. Therefore, the deed shows that he transferred the land to the vendee. Of course, he has excluded the land on which the houses were standing. But in any case, he surrendered the land to the original Rayat, who thereafter sold the suit land bearing Khata 407, 11 decimals to Gulab Chand, the ancestor of plaintiff. The plaintiffs have proved their continuous possession of the suit land by both oral documentary. Therefore, these issues are decided in favor of the plaintiff. So the basis is that 1928 Sada cell deed, because the registered cell deed, the Darayat has no right, and it goes also according to their own case. The Darayat agrees, he surrenders. It is their case, and then the recorded tenant is said to have executed that Sada cell deed. And so it is the reliance on the Sada cell deed and the documents of possession. These findings are recorded.
And adverse possession declared.
There, the court does not declare adverse possession. Court says long possession. Court says because the page 24, paragraph 13, last line, the learned first court says, therefore the plaintiff has certainly got long possession, and even if it does not mean adverse, even if it does not mean adverse possession, but certainly the land was in continuous possession of the plaintiff. And then issue number 5, that is with regard to adoption, we may skip that. And then
Adoption is valid. Adoption is valid.
Adoption, we are, so for that part we are not, is valid. There is a finding to that effect. Adoption is valid. That is coming at page 26. And then paragraph 17 would be relevant with the issue number 1, 3 and 9. From the fact and circumstances, I find that the suit is fully maintainable in its present form. The plaintiff has valid cause of action for the suit. The plaintiff have valid right, title, interest and possession of the suit land. But from perusal of the record, it appears that plaintiff has also pleaded relief regarding. Plaintiff has also pleaded relief regarding properties mentioned in Schedule A of the plaintiff. And they also plead for issuance of decree for injunction restraining the defendant from interfering upon the possession of the plaintiff over Schedule A land or any portion thereof. But from the record, it appears that they have paid court fee only with respect to the land described in Schedule B of the plaintiff. Therefore, suit has been valued only at rupees so and so for the purpose of court fee and jurisdiction, and the land covered by Schedule A covers an area of 0.21 decimal of land for which no court fee has been paid. The plaintiff has not also praised in the plaint for the land covered in Schedule A of the plaint. The plaintiff in para 3 of his has also stated that the suit land is surrounded in plot 3767, which total area is 32 decimals, but the dispute is only for 104 square feet, which has been mentioned in Schedule B of the plaint. The plaintiff is entitled for the relief only for the land mentioned in Schedule B of the plaint, and is not entitled for the relief mentioned in Schedule A of the plaint. The plaintiff is also entitled are also relief as claimed by them in Schedule 10 in the result order decreed with cost and contest that the plaintiff upon the suit land is described in Schedule B is hereby declared, and the defendants are directed to vacate the suit land.
So Schedule B property, the
104 square feet
104 square feet,
out of the 10 decimals land of item 1.
the plaintiff did not move in appeal.
No, plaintiff did not file any appeal. They accepted all the findings.
They accepted all the findings and including the finding that the suit was decreed only with respect to a portion of Schedule B.
Yes, yes. Only with respect to 104 square feet. And though there was no adjudication in respect of the main relief sought for.
What has the first appellate court
Yes,
done?
the first appellate court formulated these points. After just, it is from internal page 12, paragraph 12. And on the basis of the rival trading and contention suffering, whether the point number 1 formulated, whether plaintiff 1 is adopted son. Basically, the issues have been recasted, whether Madhu Kewat died leaving behind his 3 sons, namely Meghlal, Sikdayal and Lakshman, and if so, whether the 3 sons of Madhu Kewat had partitioned their interest in the land in dispute. Whether Meghlal Kewat have any right, title, interest over the suit land for transfer, the same to plaintiff's ancestors. Whether the sale deed executed by Meghlal Kewat is invalid, having no force in the eye of law, being violative of section 46 of CNT Act. Whether the plaintiff respondents had acquired right, title, interest over the suit land by adverse possession. Whether the plaintiff respondents are entitled to anything.
So, number 5 is important for us.
Yes. Because here the point number 4 has been determined in favor of the appellant, saying that it is violation of section 46, whereas it is also not sustainable in law, being a sada sale deed. That aspect has not been considered. So issue number 5, the findings are there. And just straight away coming to point number 4, that is at running page 18, paragraph 26. Because there is a reversal of the findings of the it is submitted by the learned counsel for the appellant that section 46 of the Chodnaku Tenancy Act as it exists in the year 1928 prohibits any rayat from transferring his right in his holding or any portion thereof by asset. He further submits that in view of the aforesaid prohibition, alleged sada sale deed executed by Meghlal Kewat in favor of ancestors of plaintiff with respect to suit land is vanished in the eye of law. It is further submitted that the court below had overruled the aforesaid contention of appellant on the basis of a decision reported in 1984, BLT 226. In the recent decision reported in 1996 in the full bench of this on court had overruled the aforesaid decision. Accordingly, it is submitted by saying that a concept for the appellant that being a full bench decision, Meghlal Kewat has sold the property in violation of section 46 of the Chodnaku Tenancy Act. Therefore, the same is invalid and no title passes through that sale deed. Accordingly, it is clear that on this ground itself, plaintiff's case is bound to be thrown out. Sri so and so learned counsel for the plaintiff respondent has clearly stated that the decision relied by the court court below has already been overruled by the full bench. Having heard the learned counsel for the parties, I have gone through the judgment of the court below and find that court below has rejected the contention of defendant on the basis of law laid down in decision reported in 1984, whereby it has been held that section 46 of Shotaku Tenancy Act, as it exists in the year 1908, is pre-constitutional law, and since the same is violative of Article 19(1)(f) of the Constitution, therefore, to that extent, it is nullified by Article 13(1) of the Constitution of India. However, it appears that the aforesaid decision reported in 1984 was considered by the full bench of our own Honorable High Court in a decision reported in 96 volume 2 pages. So, in that decision, it has been held that law laid down in Budni Mandai case was not a good law, and it has been held that section 46 of Shotaku Tenancy Act is not ultra-virus to the Constitution. Admittedly, when the court will have decided this issue, full bench decision was not pronounced. However, since the appeal is continuation of the suit, therefore, as during the pendency of this appeal, aforesaid full bench decision has come, hence same is applicable in the instant case. Under such circumstances, it is necessary to see as to whether the sale deed executed by Meglal Kewat in favor of plaintiff's ancestor is violative of section 46 or not. This bring me to see section 46 as it exists in 1900. And 46 has been quoted, no transfer by a Rayat of his right in his holdings.
Basically, the sale deed was set aside by saying that it is violating of
Yes.
section 46.
Yes.
But this particular sale deed was not a registered sale.
No, it was
a
Sada
Sada sale.
Yes, on that score also it was Sada sale. On that score also it is
But
not
it was set aside on the ground that it was a
in breach of the provisions of section 46. And that submission was raised by us also in the appeal, which is recorded in the this para which I read, para 26. That is a Sada sale deed.
then 5.
And then yes. And then here, para 28, in the finding of the landed first court has been reversed. Para
Yes,
28,
that's
I reversed the finding of court below in this respect and answered this question in favor of appellant against the plaintiff. This is also not challenged by them, this finding. Then,
Then adverse
yes,
possession.
yes. That comes from that issue. Page 20, paragraph 30. Or before that, the discussion is there. Rather, para 29 discussion is there. Their submission which has been considered side by side. Page is also 19 and para 29.
Yes.
It is submitted by Sri so counsel for the plaintiff that even assuming the sale deed executed by Meglal Kewat in favor of is illegal, being violative of section 46, and then also since the plaintiff's ancestors and plaintiff are in continuous possession of the land in dispute since 1928 on basis of illegal document, therefore they have perfected their title over the land in dispute by virtue of adverse possession. He then submits the plaintiffs and made an alternative pleadings in this respect at para 11 of the print, where they have categorically stated that Harsuklal said and Champalal said acquired an indivisible right, title, interest to the suit land and had long ago perfected their title by adverse possession on expiry of 12 years, that is on 27/5/40, to the hostile knowledge of the defendant and their ancestors. In that view of matters, the so-and-so submits that the plaintiff had acquired a valid right, title and interest over the suit land by adverse possession. On the other hand, Sri so-and-so, appearing for the appellant, had contended that in an area where CNT Act is under operation, nobody can acquire title and interest over a Rayati land by virtue of adverse possession, because CNT Act prohibits any transfer of Rayati rights by sale or any other means. For that purpose, he relied upon Honorable High Court report 1959. Thus, para 13, thus before considering as to the plaintiff respondent has acquired any right, title and interest over the suit land by virtue of adverse possession, it is necessary to consider as to whether any area where CNT Act is in operation, a person can acquire right, title and interest by virtue of adverse possession or not. After going through the judgment relied by Sri so-and-so, I find that the question raised by him cannot be accepted, because in the said decision at paragraph 26 it has been said To that, however, answer is that section 46 cannot necessarily, I think, does not by implication repeal the law regarding the adverse title as provided in Limitation Act. It is therefore been in some cases held that though section 46 is a bar to acquisition of right, interest in the holding, as a result of void document, still so far as the right of possession is concerned, that can validly be acquired by a trespasser as a result of operation of law of prescription as provided in the Limitation Act. Thus, from the perusal of opposite reason, I find that their lordship has held that any trespasser can acquire title by adverse possession. However, in the said decision, their lordship has held that a trespasser or a raiyer acquiring right title by adverse possession cannot claim any raiyyati right enumerated under Chhattarpur Tenancy Act, because a raiyyati right which is a creature of statute cannot be acquired by adverse possession. Thus, I find that opposite reason is no help to so. In this connection, it is worth to mention that Chhattarpur Tenancy Act recognized title acquired by adverse possession. Third proviso of section 71A provides that after an inquiry, the Deputy Commissioner is satisfied that the transferee had acquired the right title by adverse possession, that transferee should be restored or resettled. He shall require transferor or his heirs or another raiyer, as the case may be, to deposit with the Deputy Commissioner such sum of money as may be determined by the Deputy Commissioner, having regard to the amount for which the land was transferred or the market value as the case may be, and amount of any compensation for improvement effected to the land, which the Deputy Commissioner may deem fair and equitable. Thus, on the plain reading of the opposite provision, I find that even the Chhattarpur Tenancy Act recognizes that the title can be acquired by adverse possession. Under the opposite circumstances, contention of saying that in areas where CMT Act is in operation, nobody can acquire title by adverse possession appears to be misconceived and therefore seems to be rejected. Now, then paragraph 32. Now I am proceeding to consider as to whether plaintiff ancestors and plaintiffs are in possession of the suit land and whether they have acquired title by adverse possession or not. It is well settled that if a person entering into the possession of land by reason of an illegal transaction, he would be deemed to have begun to possess the said land adversely. A reference in this connection we made to the decision reported in 1970 Supreme Court and 1914. As in the instant case, I have already held that the sale deed executed by Meghlal Kewat in favor of the ancestors of plaintiff is invalid. Thus, if the plaintiff can show that they are in possession of land continuously for 12 years or more on basis of sale deed, in my view, as per aforesaid judgment, they can acquire title by adverse possession. Thus, I am proceeding to consider the evidence adduced in this respect.
When was the suit filed?
This suit was filed, the suit is of the year 1992.
You were in possession since when?
The plaintiff's case.
Yes, plaintiffs were in
The
possession.
plaintiff's case is that they were in possession since 1928 itself, because they have set up that story since 1928.
Then why the court is taking 12 years? What is the date on which they take?
They, according to their pleading, they perfected possession by this prescription in 1940, 27/5/1940 they say. And that pleading they are giving on basis of the registered sale deed by the raiyer. That rate which they are giving. Here,
So ultimately,
thereafter discussing the documents of possession, his appeal has been dismissed with modification of the judgment.
read para 40.
Yes. As I have already discussed about, since the plaintiffs are in possession of the land described in item 1 of Schedule A property on basis of sale deed, which is not valid in the eye of law, therefore I find that their possession over the said land is hostile to the right title interest of defendant appellant, and as such the plaintiff has continued in possession of the same for more than 12 years. Therefore, by law of adverse possession, they have acquired right title interest over the aforesaid land, as the said land is part of item 1 of Schedule A land. Therefore, the plaintiff respondent acquired title over the same by adverse possession, and accordingly I decide this question in favor of plaintiff and against the appellant defendants. And then finally referring to question 6, with reference to section 6 also.
You read paragraph 42 also.
Yes. I reverse the finding of the court below that the deed of sale executed by Meglal Kewat in favor of plaintiff ancestors confers a valid right and interest of the plaintiff with respect to the land in dispute. Because the said finding of the court below is on the teeth of the full bench decision of the honorable court. However, I affirm the judgment and decree of the court below for declaration of title over suit land and also for decree of caste possession, because I have come to the conclusion that the plaintiff had acquired right, title, interest over the suit land by virtue of adverse possession.
I affirm the title of the plaintiff over the suit land
I
and also for a decree of. So the suit was decreed.
for declaration of title
Yes.
over the suit land and
So
also
adverse possession was only allowed.
adverse possession. And here, para 40, the landed first appellate court declares right, title, interest on basis of hostile possession over the entire suit plot including schedule A.
That's right.
Schedule A, because there was no relief on that part was granted since no court fees was paid, which is also not assailed by the plaintiff, because that part could not have been given.
It was just a declaratory relief, isn't it? Because they were already in possession of it.
Because there was no court fees, the first court came to a finding that part no relief can be granted, and therefore the first court gave the relief only with respect to Schedule B, for which the court fees were paid, 104 square feet.
Yes. And the first appellate court?
First appellate court has said about the entire property in para 40. Para 40, and once again placing it. As I have already discussed above, since the plaintiff's respondents are in possession of the land described in item.
We cannot enter into the point of court fees now.
Yes, did not enter into, did not disturb the finding of court fees of the landed first court, and so without disturbing that finding, giving a declaration for again that property for which no relief was granted, and that too when no appeal was preferred by the plaintiffs against that finding.
That is not the question of law.
That is not now so far as the question of law and adverse possession is concerned.
Yes. You just cite the judgments
Yes.
and you just give me the references. You have placed both the judgments?
Yes. Yes.
Nice.
Yes.
So they were claiming title. The title was held to be invalid
Yes.
for want of permission under section 46. And the fact that they were in possession since then stood admitted, and then the adverse possession was declared.
Yes. Yes.
So first hurdle for them would be as to whether they can claim title and adverse possession simultaneously.
Yes. Yes. On that, you have given the list of books. Year 2020. Year 2020. Supreme Court 4178.
2000.
2020. It is 2020.
2020.
Supreme Court 4178. Relevant paras which I may place. Paragraph 29 at page 4186. We may also note that on the one hand, the appellants herein have sought to take a plea of bar.
Just a para number.
Para 29, 4186. Right?
Now let us see the primary facts.
Yes, that we can gather from para 2. The original plaintiff stated that he and his brother were full and absolute owners of agricultural land, measuring square.
Some just see here. What was the point for consideration by the Honorable Supreme Court?
Yes.
Issues were framed. Then what was the point of substantial question of law decided by the High Court?
paragraph 11. Paragraph 11 gives details of the findings. On the plea of adverse position, there is a detailed discussion of legal position. It refers to the findings of the honorable court in that case. Paragraph 11.
Read para 24. You wanted to read para 24?
29, I was
You read para
24. It is relevant to note that on the crucial issue of factual matrix regarding the documents and the conclusion to be drawn from them, both the courts are added. Not only grave doubts has been thrown on the story of the appellant's hearing, but both courts also record that documents sought to be produced by the appellants, that is the agreement of sale, the power of attorney, the affidavit, have too many discrepancies to be treated worth their while. This is apart from the fact that the non-registration of the title document in favor of so-and-so, appellant 1, was sought to be explained away on the ground of there being a bar prohibition on transfer of land, which aspect was however not proved by the appellants by leading any evidence. There is also adverse comment on the testimony of witness who appeared on behalf of the appellant. More so, DW2 was alleged to have scribed exhibit so-and-so. As noticed above, the conclusion of trial court was that this witness had either forgotten all facts or had been given tutored evidence, as he claimed that both exhibits were prepared on the same day, while the documents were 12 years apart. In fact, the trial court has separately set out that treasury seals were found to be raised and first dates affixed on exhibit 1. The signature of late Mr. So-and-so was also found to be raised at a particular place, and also the fact that his name was traced in the general power of attorney. These findings have been categorically affirmed by the High Court, which is the last court on facts. We find no reason to discuss this concurrent finding of the court's opinion. Even if we independently examine the evidence, there is no reason why we would come to a different conclusion.
Para 29.
Yes. We may also note that on the one hand, the appellants have sought to take a plea of bar of limitation vis-a-vis original defendant, claiming that possession came to them in 1976, with the suit being filed in 1989. Yet, at the same time, it is claimed that the wife had title on the basis of these very documents. The claim of title from 1976 and the plea of adverse possession from 1976 cannot simultaneously hold. On the failure to establish the plea of title, it was necessary to prove as to from which date did the possession of the wife of the defendant amount to a hostile possession in a peaceful, open and continuous manner. Where we failed to appreciate. On the one hand, appellants claimed that the wife of the original defendant appellant 1 herein had title to the property in 1976, but on their failure to establish title in the alternative, the plea of the adverse possession should be recognized from the very date.
30. Read 30.
Yes, we find reliance placed upon the learned counsel for the appellants in Ravindra Kumar Gerewal is also misplaced. The question which arose for consideration before the three-judge bench was whether a suit could be maintained for declaration of title and for permanent injunction seeking protection on a plea of adverse possession, or that it was an instrument of defense in a suit filed against such a person. In fact, if one may say, there was for a long time a consistent view of the court that the plea could be sealed and not assured. The judgment changed this legal position by finding that a plea to retain possession could be managed by the ripening of title by way of adverse possession. However, to constitute such adverse possession, the three classic requirements which need to coexist were again emphasized. Neg B, that is adequate in continuity. Neg play, that is adequate in publicity. And neg precario, that is adverse to a competitor, in denial of title and his knowledge. The question which confronts us is not the aforesaid, but whether simultaneously a plea can be taken. Whether simultaneously a plea can be taken of title and adverse possession. That whether it would amount to taking contradictory pleas. In this behalf, we may refer to 4 judgments cited by learned counsel for the respondent hearing, which is secondly said for the legal position. Then in Karnataka Board of Work case, it has been clearly set out that the plaintiff filing a title over the property must specifically plead it. When such a plea of adverse possession is projected, it is inherent in the nature of it that someone else is the owner of the property. In that context, it was observed in paragraph that the pleas on title and adverse possession are mutually inconsistent and the latter does not begin to operate until the former is renounced. Then the aforesaid judgment in turn.
So you want to say that once the title was, they claimed adverse possession with respect to the same deed.
Yes. They, on the one hand, they say that we have a title document. We are the rightful owner by referring to the sale deed. Firstly referring to the registered sale deed, then admitting that it was surrendered, and then saying that the recorded real, admitting Madhu Kewar to be the recorded real, and saying that the land was transferred to us by a Sada deed. So there they admit ownership of a person, that he is the owner, and they also admit
That
that
person is a party. The
Yes.
real owner is a party.
yes, their legal heirs are the appellants over here. Their legal heirs. So here they came out with a plea. It is not their simple case that the other side is not the owner, and we have perfected simply by way of adverse possession. But here they first of all they came out with a plea.
That they are the owners.
Yes, they are the owners on basis of the title.
So they by themselves did not acknowledge that anybody else is the owner.
Yes, yes. And so this is what cannot be permitted. These are mutually exclusive, excludable pleas, which is not allowed by. Then further, if I just read through the paragraphs, para 33, this Mohanlal's case also is considered. Para 33, as regards the first plea, it is inconsistent with the second plea, having come into possession under the agreement. He must disclose his rights thereunder and plead and prove assertion of his independent, hostile, adverse position to the knowledge of the transferor or his successor in title or interest, and that the latter had acquiesced to his illegal possession during the entire period of 12 years. That is, after completing the period of his title by prescription, neg claim. Since the appellant's claim is founded on section 53A, it goes, that is Transfer Property Act, it goes without saying that he admits by implication that he came into possession of the land lawfully under the agreement and continued to remain in possession till date of the suit. Therefore, thereby the plea of adverse possession is not available to the appellant. Again, this judgment also, these findings, similar is the fact there. Their basic is that by virtue of that said deed, they came into possession. The first deed they refer, registered sale deed, then surrender, and then. In order to establish adverse possession, an inquiry is required to be made to the starting point of such adverse possession, and thus when the recorded owner got dispossessed would be crucial. In the 35, in the fact that this fact has not been proved, the possession of Srimati so wife was stated to be an account of consideration paid, assuming that the transaction did not fructify into a sale deed for whatever this reason, still the date when such possession becomes adverse would have to be set out. Thus, the plea of adverse possession is lacking in all materials. The possession has to be in public and to the knowledge of the true owners as adverse, and this is necessary.
Now, yes, having seen this judgment, now let us look at the questions of law.
Yes.
So far as the first is concerned, in absence of any, you see, plea was there of adverse possession.
It is there.
Finding was not there.
Yes.
No clear finding was
Yes.
there. First appellate court is coextensive. The first appellate court has to decide all the issues.
Yes.
So, first appellate court having decided the plea of adverse possession, what remains in substantial question of law number 8?
Yes.
Read it.
Yes. Now, whether in absence of any finding of adverse possession by the trial court, the lower appellate court could have given a finding that the plaintiffs had acquired right, title, and interest by adverse possession.
Yes, could have. There is no legal bar. First appellate court, suppose any point is left out by the trial court, that finding can be given by the learned first appellate court.
Assuming
So,
that
there is no problem so far as A is concerned.
Yes, sir.
Right?
Then B is
B.
which may be relevant for
Yes.
whether the learned lower appellate court has committed an error of law in not deciding the issue number 8 framed in the trial court in its true perspective.
Issue number 8 was?
That issue of adverse possession.
In its true perspective means what?
In its true perspective means appreciating the attending facts by applying the relevant law, by applying the relevant principles of law.
You see, whether foundation plea was there, may be incorrect. But foundation
Yes,
plea
yes,
was there.
Some pleadings were there.
Pleadings were
Pleadings
there.
are
They gave a date
Yes.
also
Ah,
as an alternative
yes,
plea,
yes,
right? So that perspective is there. Maybe that it was not possible to take an alternative plea.
Now,
So far as that perspective as to the basic plea of adverse possession is there, there is nothing on record to show that you ever contested their or disputed their possession. Possession, etc., is not in dispute.
we have contested. Our written statement is concerned.
That's right, but everything has been
Now-
taken into
Now,
consideration.
one thing.
When you say in its true perspective,
There is
please explain what is that true
true
perspective which has been
perspective is
omitted.
so far as while deciding the issue, every aspect has to be considered.
Which aspect has been left out?
Facts and the law.
Which aspect has been left out?
Now the aspect that it is a plea which is contradictory to the original plea. Mutually exclusive plea.
Okay.
That has been left out.
That has been left out.
Yes.
Okay, fine. So B is confined to the issue that it was mutually exclusive. Apart from that, everything is there.
It is there, but that part, since it is a
We'll take care of
basic
that.
requirement.
Because since true perspective is not well defined in the question of law, so I am asking you, what is that true perspective? True perspective is, as per you, that it is contradictory, that aspect has not been considered.
Yes.
Okay.
It is
And
contradictory.
therefore B and D are the same.
B and yes. And one more thing I would like to add there, true perspective. That is one part mutually exclusive, and other is that it has not been considered if they have admitted ownership of the land in name of a particular person. They have admitted. So
No, they admit because they purchased from that person.
yes.
So they have not disputed the original owner.
They are the root of adverse possession by virtue of Article 65.
They have admitted that the true owner was such and such,
Such and such.
and they purchased from such and
Yes.
such. But that particular sale deed having been held to be illegal for want of permission, so they claim that irrespective of that, they have the adverse possession.
That is the thing which the learned first appellate court did not appreciate in right perspective.
No, the court has appreciated. We have read the full
The
text.
learned court has appreciated,
Yes.
but not in the right perspective.
What is that right perspective?
Yes, right
which is
perspective is that to come to a finding that one person has perfected his title by way of adverse possession. There it has to be seen whether that person he is disputing, or in this case that person is admitting. The moment he admits that so and so is the owner, there cannot be an issue of a claim of adverse possession, because that admission cannot be there, which is the basic. Because that admission is coupled with the fact that not only that admission, they admit transfer of title through that actual owner. So that thing has not
So they have not acknowledged the title in the true owner.
Yes, they have not denied that the person had no title. That would have been.
No, firstly they have to accept that he has a title, but in spite of that, one has perfected the title by adverse possession.
Here the fact.
First is the acknowledgement of title with the true owner,
And then
adverse possession.
Then adverse possession.
So once they claim the title by virtue of a sale deed, they do not accept that he is the true owner of the property. It was only when the court declared, they took an alternative plea with respect to adverse possession, assuming that if the title is not declared, my adverse possession will.
Yes, so there it has to be. It was required to be appreciated in that manner. They admitted that the so and so Madhu Kewat was the true owner. They also admitted that it was transferred by Madhu Kewat. The moment you are admitting
that it was already transferred.
So it is something. It is permissive possession. It cannot be the root of adverse possession. It is something which is a permissive possession, and therefore it was the basic thing which would demolish their case for getting a relief by adverse possession, because it is something which is clear permissive possession.
Even in case of permissive possession,
It cannot be an adverse possession.
I should. For permissive possession
Because
also,
it
you
will-
have to say when did it become adverse.
Adverse, and here it will again come to the same principle basically, which we have said. The main thing which this honorable court has said ki it will be taken care of mutually
Okay.
exclusively.
That's
It is
right.
basically it is all correlates to each other.
Okay.
The basic logic is that
Then
same.
C, what is C all about?
Regarding title interest and right title interest in favor of plaintiff on basis of exhibit 2 and 2 by A. Now 2A is the registered deed.
2 is
The 2 is the registered deed.
dated.
That is 27/5/1928. 27/5/1928. By the Darrayer.
Okay, by that
Yes.
in favor of the plaintiff.
In favor of the plaintiffs.
This is preceded by Sada deed.
No. Thereafter, Sada deed comes.
Okay.
First, they say it is their case. The Darrayer sold them by registered deed. Then they say the recorded tenants, Rayas, that is our forefathers, they objected. Then they say the Raya agreed to surrender it, and there was an understanding between them. The Raya would surrender to the original Raya, and then the original Raya would sell to them. And then they say that after the surrender, the Sada sale deed was made.
What is the date of Sada deed?
Sada sale deed is of August 1940. I am giving the exact date.
1940.
37.
28 only.
And 28/5/1928 is the registered sale deed. If I stood corrected, 28/5/1928.
Yes.
That is the first sale deed. Then 3/7/1928 is the deed of surrender by Laldev Chaudhary, the Darrayer. 3/7/28, which is their case. And then
Just a moment. This deed 27/5/28, registered deed
yes,
by Darrayer,
Laldev Chaudhary.
Laldev, in favor of
In favor of Harsuk Ram Seth and Champalal Seth.
Said. Okay. Then
the date is I should correct
just
it.
then Laldev surrendered.
Thereafter 3/7/28.
3/7/28.
Laldev, the Darrayer surrendered.
Surrendered in favor of
Meghlal Kewad. The
Kewad, the Rayat,
yes.
and then Meghlal
Yes. Executed the Sada sale deed.
in favor of
In favor of Ramchandra Seth and Gulab Chandra Seth.
the Sada said it is dated
7/7/1928.
7/7/1928. Which said it has been declared to be void?
This
The surrender?
No, this 7/7/28.
7/7/28.
Yes.
Being violative of
Section 46.
this is not a sale deed technically.
But the learned
Maybe
person,
this is not the sale
because if the judgment is against it, there is no specific address to which of the sale deed is declared. But it is said that they transfer by the cell leads is in contravention of section 46. We made a plea, simple plea, that since it is a SADA cell lead, the Registration Act was very much there in force at that time, and so by SADA cell lead, a title cannot be passed in respect of an immovable property having value of more than. And therefore, once it is their case, once they say that, look, he is the Rayyat, they admits, and then they say that through him we have come into possession, and thereafter they cannot say that our possession is adverse. That is what.
थोड़ा सा लिखिएगा तो नीचे. As per the appellant, one registered CD dated 27/5/28 was executed by Dalraiyat Laldev. Laldev का पूरा नाम क्या है?
Laldev Chaudhary.
Laldev Chaudhary in favor of Harsukh Ram Seth and
Harsukh Ram Seth and Champa Lal Seth.
Champa Lal Seth. Thereafter, he further submits that since the Rayyat was not entitled to transfer the property, Laldev Chaudhary surrendered the property on 3/7/28 in favor of the Rayyat, namely Meghlal Kevat. Which was then Meghlal Kevat executed Sada sale deed dated 7/7/1928 in favor of Ramchandra Seth and
Gulab Chandra Seth.
Gulab Chandra Seth. Who is Gulab Chandra Seth and not by Chaman Lal Seth?
Yes, because it is the pleading of the plaintiff that they all belong to the same family and these properties has devolved to him. It is his case as set up in the plaintiff.
And as per the plaintiff, Harsukh Ram Seth, Chaman Lal Seth and Gulab Chandra Seth belong to the same family. The sale deed which has been declared to be void for want of permission under section 46 of Chotanagpur Tenancy Act is sale deed dated.
So far the judgment is concerned, it does not specifically addresses which one. It says whether the sale deed executed by Meghlal Kevat, meaning thereby the Sada sale deed. The issue is there, the points which were formulated in the first appeal, paragraph 12, is point number 4. Sale deed executed by Meghlal Kevat is invalid, and Meghlal Kevat executed this 7/7/1928 Sada sale deed, as per the case of the plaintiff.
The learned counsel submits that it was the Sada sale deed which was held to be violative of, which was held to be invalid on account of absence of permission for transfer under section 46 of the Chotanagpur Tenancy Act. With respect to the substantial question of law number A, the learned counsel has submitted that the learned counsel could not dispute that if any point which arises for consideration upon reading of the plaint and the written statement before the learned trial court, and if not decided, the same can certainly be decided by the learned first appellate court, as the first appellate court is the final court of fact and also law. Correct? He has nothing much to say so far as the substantial question of law number A is concerned. With respect to substantial question of law number B, the Learned Council has submitted that the Learned First Appellate Court has committed an error of law in not deciding the issue number 8 within bracket adverse possession framed by the trial court in its true perspective, and while referring to the term true perspective in the substantial question of law, the Learned Council has submitted that one of the basic ingredients for claiming adverse possession is the plaintiff must acknowledge the right of the title of the true owner. He submits that in the present case, and also the fact that both the plea of adverse possession and title being conflicting in nature is not permitted to be taken simultaneously. The Learned Council has submitted that the plaintiff was claiming title over the property by virtue of Sada sale deed dated Seven 1928 and asserted that, and the plaintiff also asserted that they perfected the title in the year 1940 upon completion of 12 years from 7/7/1928. The Learned Council submits that the date of possession by virtue of Sada sale deed dated 7/7/1948 claiming title and the claim of adverse possession are both referable to the same date, and the plea are conflicting. He has relied upon the judgment passed by Honorable Supreme Court reported in AIR 2 2020 SC 4178 within bracket Narasamma and others versus A. Krishnappa through legal representatives, and has in particular referred to paragraph
24 onwards up to 29 and then
paragraph 24 to 29, from paragraph 24 onwards. With respect to the substantial question of law number D, the Learned Council has submitted that the Learned First Appellate Court could not have held, by holding that the sale deed was invalid, could not have decreed the suit by holding that the plaintiff acquired their right title by adverse possession, as the claim of title through sale deed and claim of title through adverse possession cannot be taken simultaneously. And he refers to the aforesaid judgment once again.
and one factual assertion about the date which they have pleaded. Para 11, they have taken the date of the registered sale. And para 11, they have pleaded that they have perfected title by adverse possession on 28/5/1940. 27/5/1940.
The Learned Council has submitted that
5/1940.
The plaintiffs claim that they perfected the title by way of adverse possession on 27/5/1940, and this date of completion of 12 years is referable to the registered sale deed dated 27/5/28 and not 7/7/1928, which is the Sada sale deed.
Yes, that registered sale deed is dated 28/5.
28/5, ठीक है. ये जो 28/5 का डेट है, this deed has been declared invalid.
This has not been declared invalid.
During the course of argument, it appears that the registered sale deed dated 28/5/28 has not been declared invalid.
And it was executed by the Dharaya.
Even if it was executed by the
Dharaya. And it is the plaintiff's own case that the Dharaya surrendered the land. So the registered sale deed, the validity of sale deed is itself.
The learned counsel submits that it was the specific case of the plaintiff that since the debtor did not have the right to execute the sale deed, the debtor surrendered the land, which was followed by a Sada sale deed. With respect to substantial question of law number C. Okay. The learned counsel has submitted that Exhibit 2 was the
that is the sale deed.
registered.
Exhibit 2 is the surrender.
Exhibit 2 is the document of surrender, which is dated 3/7/28.
And 2/8.
3/7/28 by the Darrayat Surinder
Laldev Chaudhary.
by Laldev Chaudhary in favor of the Rayat, namely Meghlal Kewat, and Exhibit 2/A is the
Sada sale deed.
is the Sada sale deed dated 7/7/1928, executed by the Rayat, namely Meghlal Kewat, in favor of Ramchandra Seth and Gulab Chandra Seth. He submits that these documents have not been properly considered by the court. क्या बोलेंगे, इसमें तो कुछ फाइंडिंग ही नहीं है. इसके बेसिस पे क्या फाइंडिंग है? कोई फाइंडिंग नहीं.
इस बेसिस पर, so far as this basis is concerned, the court says, considering these documents, that these are from these dates they have been in possession, or these documents are the title documents. The court says, the first court says.
Appellate court has not accepted.
Appellate court has not. Appellate court has said.
Both the courts क्यों लिखा है?
Appellate court has said Exhibit 2/A is in breach, but the first court has relied upon this sale deed, Sada sale deed.
The learned counsel submits that the learned trial court had confirmed both title and adverse possession.
Title and possession, because
Both title and possession
and possession.
in favor of the plaintiff. The learned first appellate court rejected the claim of title, but decreed but on the basis of possession declared adverse possession of the plaintiff.
yes,
Okay.
over the entire land.
Over the entire property.
Though first court gave the declaration only in respect of Schedule B.
Though the first court had given the declaration of possession. This is not good.
And the declaration, the first court, the finding is there. I'm just reading the finding of the first court. The plaintiff has not pressed the cover in Schedule A. The plaintiff in para 3 stated the surrounded so-and-so total area. The plaintiff is entitled for relief only for the land mentioned in Schedule B of the plaintiff, and is not entitled for the relief for the land mentioned in Schedule A of the plaintiff. This is paragraph 70. The final.
Although the learned trial court granted relief only in connection with Schedule B of the plaint and not Schedule A of the plaint, after having recorded that the plaintiff was in possession of the entire suit property. Schedule A was in possession with respect to Schedule A property. Schedule A का तो possession दे ही दिया था ना, finding तो था ही.
लेकिन ये जो ये है, entitled for the relief, जो relief grant की, relief जो decree is there only for schedule B. ये clear
इसको
है.
ऐसे लिखेंगे ना कि although the learned trial court had given relief only in connection with schedule B property,
Yes.
the learned first appellate court has declared adverse possession with respect to the entire property including schedule A and B.
And one judgment was there, that which the learned first appellate court says that even if a document, title document is illegal or void, but the possession on that basis will be adverse. That is said in the case of this Kurela Naga Dhruva Vidya. That possession under an invalid sale deed, it cannot be said to be hostile to the true owner. So on basis of an invalid sale deed, one cannot claim.
The learned counsel has submitted that on the basis of an invalid sale deed, a person cannot claim adverse possession referable to the date of possession pursuant to the invalid sale deed. He has relied upon the judgment passed by the Honorable Supreme Court reported in
2008,
2008,
volume 50,
volume 15, 15,
15,
SCC,
page 150.
page 150. Para number?
Para 19.
Kurela Naga Dhruva Bhaskar Rao. Page number, para number?
Para 19.
Para 19 में कहाँ लिखा?
Para
There was a concurrent finding. कहाँ लिखा?
एक question. There were two questions were framed. Question
तो
one.
ये पैराग्राफ तो कम से कम सही से बताएंगे.
हाँ नहीं बता रहे.
बताइए.
Two questions were framed.
Which paragraph are you referring?
Yes.
No, it is not applicable. ये citation का कोई जरूरत नहीं. I will. इसको हटा दीजिए, इसका कोई जरूरत नहीं. ठीक है, आपका argument concluded. The learned counsel for the appellant has concluded his argument. I have heard you for the whole day. कल फिर से शुरू मत हो जाइएगा. कल आपका argument. Pose this case for argument of the respondents.